In item number 15, Lordship, I have filed one key petition for confirmation, substitution, and setting aside. So that may be allowed to
outcome submit that he has filed 3 applications. So that
no, that is not the
taking into account the above, list the matter again on 3rd of June 2024, along with
item 15. Order perfect.
Madam, item number 8, my lord, 2 very relevant documents, my lord, the LPSA has not been annexed, my lord. I have to take that on record. So,
you have to file an additional application. B.S. Goyal, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation of 2 weeks for filing an additional affidavit to bring on record certain documents. It's the matter on 3rd of June 2015. Huh?
wait for the date.
3rd of June.
I'm ready.
Please, Your Lordship. That's why back to mention item number 45. With the permission of the other, better to be not for that.
45 is for what?
That will be the transfer petition.
What is that?
Transfer of a civil.
What is that? Why do you need time?
The conflict is out of state.
Not necessary. You be there.
Any shortage may be given, but
Transfer petition has to be finished on the first. No.
no 47.
I'll do you. Well, there's another appeal. You can't file 2 appeals.
I only paid that one. Or I have transferred now.
Huh?
So far, I cannot be so if I decide lordship, then perhaps I cannot establish a second transfer. But I may be allowed to do this particular to liberty to grant the earlier case by the big.
You were supposed to file that application.
Yes.
That leave is already granted, liberty granted. You have filed it. Couldn't have filed the second one. It is already there. Why should I say anything? If you had filed this application, it would come up. Explain your delay and file an application. This is as regards the delay in filing the accompanying appeal, the respondent had 7 and 8. Now the appealant has also expired.
The appearance expired, my lord, 2015.
Understood?
Yeah. I'll expect left.
Huh?
Yeah, I'll expect. Yeah. And another thing, my lord.
And the best part is this. Where's the other? The first case is of
2015.
the file. There is a delay of 46 days. Wakalatnama not executed by the appellant. Decree at page 101.
Case number 4, that status concept.
How did you file it?
My lord, what happened in earlier case, Okalatnama, why they have not executed the title appeal which was filed. Initially, suit filed by the 4 plaintiff, out of which only plaintiff number 1 filed title appeal before the learned court below. Then against that dismissal, both the court dismissed the suit, then filed the second appeal by naming 4 persons. Now 4 persons. Title suit by all. Title suit by all. Then title appeal. Kindly see the title appeal before the learned court below by 1 person only. Kindly see this title appeal before the trial court. Lower appellate court.
What is your name?
Yes,
Huh?
Yes,
S. Hawk.
Yep.
You were there in this case and earlier case also. Who were there? You were there. Both cases you were there. Then how is it possible? Tell me. Did you mention in your application earlier that you had filed an appeal? In the next case you have said the appeal has been filed.
Yes.
Then what happened? What did you say thereafter?
In delay condonation.
Now, what is your explanation after this? As regards your delay condemnation, Ali Akbar died on 1/9/2015. And during the lifetime, he told the legal representatives about the filing of the instant appeal. Then why didn't you file all this while? Why didn't you take any steps out this? And why did you file after 1434 days? What is your explanation?
So, the earlier scholarship, while he came and gave the effort, then he went and then he fell on illness.
No, understood.
Yes, sir.
Understood about Ali Akbar. But you say in paragraph number 4, the applicant states that their father, Ali Akbar, told them that a regular second appeal has been filed in the Honorable High Court, meaning thereby they had knowledge prior to 1/9/2015. Because 1/9/2015, after that, the ghosts cannot come and say that we have filed a second appeal. So he must have said it prior to his death. Then why all this while no steps was taken?
They were party in the plaintiff. All the legal heirs are party in the as a plaintiff in the suit.
How do you take care of this situation?
Then, worship, when it is after lordship, I could communicate with them, worship. Then also I meet and then teacher lordship came to know.
No, it is not your duty. It's the duty or the inclination of the persons to come before this court. You cannot force them. Isn't it? So under such circumstances, in this case, you did not file an application for condoning the delay. That is another thing. But in the other case, how do you take care of this delay? There's no explanation. Because they know very well that all this while, their father, prior to their death, told them that this is an appeal which has been filed. How do you explain the delay of 1434 days?
When they know, but they could not communicate, but they also tried, but they could not communicate us. Communicate to
Mr. Hawk, there's nothing to do with you. Kindly explain, kindly acknowledge the fact that this court is not pointing any finger upon you. It is not your responsibility. When you spoke to one Rabiul Islam,
review.
you could find out that Ali Akbar was not in good condition. He was given rest till 31/8/2005. 15. On 1/9/2015, he expired. Prior to that, he told these people, all his sons and all, that look here, there is a judgment and I have filed an appeal, kindly take care of it. They did not do so. What else? What is the explanation thereafter? Nothing. We do one thing. We dismiss this condonation application. Once we dismiss this condonation application, then all other things go. The fact that there was an appeal file is there. But the appeal was filed, there were many defects. That was never cured. So under such circumstances, this appeal also has become useless. They can't really agitate this appeal because of the dismissal of this
Yeah.
by the same persons.
And apart from that, it was abated.
Understood. That is the appeal has
Automatic-
already, that
automatic
appeal
abate.
which was filed with the filing number has already abated because of the death.
Yeah.
Then they filed out this
Yeah.
appeal. But here there is no explanation. Mr. Counsel, why there are two sides of a story? Kindly come to IA number 1383 and IA number 758. Both has different stories. Why? Why there are two IAs?
For contestation delay lordship.
Hmm?
Actually, earlier lordship, another I was filed lordship. But
Why?
yes,
Why there are two IAs for one condonation of this?
earlier on, they withdrawn.
Which one?
Earlier on,
Or you withdrew this?
yes,
1383 you have withdrawn.
withdrawn. To be limited to substitute the other legal debt lordship. Yes, but
No. 780. Huh? IAC 780. Heard Mr. S. Hock, the learned counsel appearing on behalf of the applicant, and Mr. S. K. Ghosh, the learned counsel appearing on behalf of some of the opposite parties. Some of the opposite parties or all?
1 to 7.
Some of the opposite parties. Some of the opposite parties. Some of- This is an application for condoning the delay. This is an application under Section 5 of the Limitation Act for condoning the delay of 1434 days in filing the appeal, accompanying appeal against the judgment and decree dated 5/12/2014 passed by the learned civil judge Walpara entitled Appeal Number 3 of 2006, whereby the judgment and decree dated 30/9/2013 passed by the learned civil judge Junior Division Number 1 Walpara entitled to number 12 of 2000 was affirmed. This court finds it very relevant to take note of that prior to filing of this accompanying appeal, the predecessor in interest of the plaintiff of the applicant's hearing had filed an appeal challenging the same judgment and decree.
But earlier predecessor of the appellant along with the applicant number 1 to 3.
Along with the applicant numbers
Number
1, 2, and 3.
Three.
1, 2, and had filed an appeal.
Not 1, 2, 2, 3, and 4. 2, applicant number 2, 3, 4.
Before further proceed, before dealing with the instant application, now it is relevant to take note of that the judgment and decree dated 12/2014, passed in title appeal number 3/2006, was challenged by filing an appeal by the predecessor in interest of the applicant number 1.
Predecessor of the interest of the applicant. Applicant, all the applicants. They are the 2, 3, 4 are the party in the appeal, earlier appeal.
Had filed an appeal by the predecessor in interest of the applicants, one Ali Akbar, since deceased, along with the applicant numbers 2 to 5 herein. The said appeal, though filed, the said appeal, upon being filed, was issued a filing number bearing 253896. On the account of there being a delay of 46 days, and various other defects, including the fact that the appellant's number two to 5 in the said appeal filed in the year 2015 did not sign the wakalatnama. The said appeal was not registered. A perusal of the instant application shows that a counsel who had filed the appeal in the year 2015 duly intimated Ali Akbar, say late Ali Akbar, about the said defects. However, those defects were not rectified. On the other hand, on account of illness, late Ali Akbar expired on 1/9/2015. It is categorically stated in paragraph number 4 of the present application that late Ali Akbar duly informed the applicants herein about the filing of the said second appeal in the year 2015, and the same was lying defective on the grounds which were duly intimated to him by his counsel. Thereupon, there is nothing mentioned in the said application, in the instant application. Why? Immediately after the death of Ali Akbar, steps were not taken for rectification of the defects in the regular second appeal filed in the year 2015. Or for the purpose of filing the present appeal. It was after 1434 days. And it was only on 8th of February 2019 that the present appeal has been filed, accompanying appeal is being filed along with an application for condonation of delay, which was registered as IAC number 1383/2019. This IAC 1383/2019 was withdrawn by the applicants on account of the death of the respondent number 7 and 8 to the said application, with the liberty to file a fresh application. And accordingly, the present application was filed. On 3/1/2020. 3/1/2020. P1 or P2? 2000. In the backdrop of the above, this court have heard the learned counsel, Mr. S. Hawk, who was not only the counsel in the instant proceeding, but was also the filing counsel in the earlier appeal filed in the year 2015. I've also heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf of some of the opposite parties, and have given due consideration to their respective submissions. The question therefore arises as to whether the delay of 1434 days in filing the instant appeal could have been condoned, can be condoned. In filing the accompanying appeal can be condoned. This court have duly taken note of that in the first appeal, in the appeal filed in the year 2015, although the applicants' names number 2, 3, 4, and 5 were duly mentioned as appellant numbers 2, 3, 4, and 5, but the said appellants did not, appellant did not sign the wakalatnama.
As well as they did not file title appeal. That
Did not sign the wakalat. Therefore, the said appeal filed in the year 2015 cannot be said to be an appeal filed by the appellants numbers 2, 3, 4, and 5 in the appeal filed in the year 2015. The said appeal has to be therefore constricted to be an appeal filed by late Ali Akbar, and upon his death, it was the responsibility of his legal representatives to take appropriate steps in that matter, which included the applicants number 2, 3, 4, and 5, who were the sons of late Ali Akbar. Be that as it may, no steps were taken, and the said appeal was kept defective in state where remained in a defective state. All these were till date. Next. In the meantime, the applicant numbers 1A, 1B, and 1C along with the applicants number 2, 3, 4, and 5 filed the present appeal, accompanying appeal. Along with the condonation application for delay, for condoning the delay of 1434 days. In the same condonation application, it has been specifically mentioned that Ali Akbar expired on 1/9/2015. It is also stated that late Ali Akbar, before his death, also informed the applicants about the filing of the case, in the filing of the appeal in the year 2015, and it was lying defective. There is no explanation whatsoever in the instant application as to why then no steps was taken for removing the defect in the appeal filed in the year 2015, or a fresh appeal was not filed. For till 8/2/2019. Taking into account that instant application is bereft of any detail, sufficient cause being shown, this court therefore rejects the instant application for condonation of delay of 1434 days in preferring the accompanying appeal. Accordingly, the instant application stands rejected. The consequential effect of rejection of the application for condonation of delay, of the instant application for condonation of the delay, is that the accompanying appeal, which was filed on 8/2/2019, cannot be entertained as it had become part by limitation. IA therefore stands dismissed with the following observations. Baki IA पूरे, उसमें बाकी IA सबको बनाए. I'm not saying anything about you to think whatever you feel. You can remove the defect. Do it. But you will have a big problem there also. Because you knew that about that thing. How do you explain for all these while till 2019? Till prior to that, after 2019, you can very well say about it. But what will he say prior to? And you said in paragraph number 4 that at the time of death,
They extend or if that case that court.
hello. I have to go you, huh? The registry, the records of the appeal filed in the year 2015, bearing filing number so and so is segregated. Yes, from where do you want to go?
Please, Lordship. 5 of the application, the petitioner in
From
for the
Punitpur to Kamrup.
Yes, Lordship.
Why?
The petitioner is not working lately, Lordship. He is residing on the state of a
Hmm?
parents, Lordship. He is residing at Guwahati on the state of our parents, Lordship. And moreover, Lordship, the petitioner has received petitioning from the respondent, Lordship.
Slowly, tell me. What is it? You stay in Guwahati.
Yes, Lordship.
Respondent stays where?
The test school, Lordship.
The respondent has filed a case there.
Yes, Lordship.
What case?
Matrimonial case, Lordship, for divorce petition.
Marriage where?
Marriage was solemnized at Guwahati, Lordship, in the year 2023, Lordship.
Then
Then
last lived. Where did you last live together?
at test school, Lordship.
Left.
The petitioner was residing at Guwahati at the time of the presentation of the divorce petition.
Who? You.
Petitioner, Lordship. Yes,
Okay. But last marriage, last resided at
test school,
Punitpur.
Lordship.
Yes. Why you can't go there? What do you do?
Lordship, the respondent just pretend me that I will have to face dire consequences if I ever seen in test school, Lordship.
Have you filed an FIR?
Yes, Lordship.
Where?
The page number 11 to 16, Lordship, Annexer 1, Lordship.
Hmm?
Annexer 1, Lordship, page number 11 to 16, Lordship.
When this is of 2024.
Yes, Lordship. The last line of the FIR.
When was the case filed?
It was what testimonial.
When was this filed? 10th of April.
Yes, Lord.
Case was filed in 10th of April.
Yes, Lordship. And the next date is.
And you filed the FIR on 4/4.
Yes, Lord.
What happened on the last date? After 2 days.
Petitioner went to the matrimonial home, Lordship. Petitioner and along with his her parents, Lordship. Then the petitioner was not allowed to enter into her room, Lordship.
Huh? To notice making it available on 19th of June 2024. Step be taken by registered as well as usual. It is even that the petitioner is direct to take steps by way of the three the basis of the file and affidavit. It is made clear that it is not required for the petitioner for herself to take the step by way of the state to be that as a person. However, the state person has to file an affidavit of service. This court have duty to take it note of. This is an application of the section 24 of the Code of Civil Procedure for transfer of title to matrimonial case number 72 of the 2024 pending before the court of the learned district judge Punitpur Tejpur to the court of the learned principal judge family court Kamrup Metro. It has been alleged that the petition What do you do?
Not what?
There's been alleged that the pursuant to being not allowed to enter her patrimonial home by the respondent, for which the petitioner had filed an FIR. Have been residing at her parental home at Guwahati. Further to that, it has also been averred that the petitioner has no source of income, and it would be difficult on the part of the petitioner to therefore appear before the district judge, Punitpur, Jethpur, in respect to the aforementioned matrimonial dispute. Considering the above report, the opinion that the fit case for stay of Title II matrimonial case number 72 of 2024, pending disposal of pending in the court of the learned district judge Punitpur Jethpur till the next day. It is, however, made clear that to the appearance, this court, however, puts the petitioner to the notice that in the circumstance the petition is allowed or disallowed on the next day, the petitioner thereupon shall be has to file their written statement in the statements. Pursuant to such orders that may be passed. Get yourself, make your written statement ready by now. What is it? Why, this is the same type of matter that day I heard. The Ganguly is there. None appears on behalf of the petitioner on call. I don't understand why there is another matter. See, if go on, ask Mr. A. Ganguly to appear, somebody. A. Ganguly to appear. Phone number.
By order to the 2023 Lordship, the case was directed to the expertise against them.
Why?
Page 34 Lordship.
34?
Page 34, order to the 28/2/2023. The MSC case.
There is the case, hence the service upon the offense seems to have been served by the Please absent today, they are then
Well, subsequent Lordship, we appeared on 5/3/24.
you filed an order 9 rule 13.
Lordship is a wrong. Lordship, page
Then
39 Lordship, may kindly see the order of rejecting our petition Lordship.
How do I help you with such type of
Written statement is on record. The statement is on record.
understood, but how do I help you with this type of petition?
It's like no proof of source, my lord.
I think you are that you want to go this it is more like a petition on the order 9 rule
Yes,
7.
sir. admit, and the
Well,
no book was shown, my
how do
lord.
I help you?
But the problem is that lordship, the company was different at that time. Company was different.
What company?
That was a different company, lordship, Bharti Ekta. So that was merged with the present insurance company.
When?
Lordship, I have NXT one certificate, lordship. That is lordship, Annexer 10, lordship,
Annexer?
10. This is the reason, lordship. Page 35. Page 30.
But then also, how do I help you? The records and files were not there. There was no notice to you.
In fact, there is no notice to you that notice was forwarded by the Bharti Ekta after merger to us. Then we appeared.
Did you explain it in your petition?
Not in the lower court, lordship. Yes, yes, yes.
Yes, Mr. Ganguly. What is this this petition? Show him the file. Isn't this the same type of matter that they have taken?
Yes,
Dasarat Prasad.
yes, and the same, and in that case, my lordship said issued notice.
Yes. Why you are not here when the matter is called up?
Look, I was in the neighboring court, Lord, I'm sorry for that.
Then you dismiss for default.
No, Lord, I'll argue that time.
The same order 23-9,
Yes, 27-9.
27-9, and you have filed it in the year 2024.
Yes. Lordship said have issued notice in the other CRP and fixed it on 17th of June.
So we do the same order. The same order. Do you have the number of the earlier CFP?
Yes, CRP IO 140 of 24.
The June order was passed on 27-9,
27.
and the earlier was 23-9.
No, the impugned orders, both orders same court because both the suits are going on in the same court and both are fixed
All
on
are
same.
same. Everything is same.
Same.
But there is no stay now.
There's no.
So
Lordship
the
said,
filing date is same, 8-4.
yes, they were filed together. Oh, no. 17th.
17 June is off. We
I
fixed it
recall
on
from memory
19
because the order is not uploaded yet. I am
19th. Because 17 June is some holiday.
that is why I'm
I think that has been corrected.
Good.
I think Vijay must have been. 17 June was it?
both the petitions on the same day. Both petitions on the tablet.
19th, because 17th is holiday.
The tablet.
Yes, have you explained all these things?
Lordship, para 9, there are 10,
A Ganguly, okay?
para 9, 10, and 11, lordship.
You have explained that.
Yes, sir.
Did you notice making it returnable on 19th of June 2024? So some steps be taken by way of registered as well as usual within 3 days. According to 3 days. So in addition to that, the petitioner is also directed to take steps by way of serving a copy of the petition. When is the next day fixed before the
Lordship,
trial
in
court?
fact, the case is fixed today, lord.
It is for DW.
At that
No,
stage,
no.
we had
Well,
a-
no. How do you say that it is fixed for today?
It was as per the order dated lordship 5/3/24. The case was fixed on 8/4/2024.
What happened then?
Case is proceeding.
Did you submit any defense with it?
No, lordship. You could not file this statement, lord.
Understood, but then also the court permitted it.
It's for other officer.
Now, what is the next day?
Today is a date.
How do you know?
The client informed me. Company is informed.
You're sure the matter is not pending? It is not disposed of.
Lordship, again, I will take lordship. The court. Okay.
We'll take it up at 2. Just find it out.
Right.
It is how MSC case number 436 of 2022. For the court of the member MSC. Huh? Type the open division by 1230. by 12 o'clock, let me
Lord.
pass the order.
Lord.
What is the next step? Get an order nowadays, it's available on the thing.
Yes.
Part of 12 o'clock.
Petitioner has plaintiff filed an application put a learned child put below, seeking to amend an issue of right title interest. Because during
Which order is the impugn order?
7-2,
Huh?
7-2-2024.
Yes, what is that
At page number
application you have filed?
67. At page number 67, Lord.
For order passed in petition number 1171 filed by the plaintiff keeping the
Lordship,
remaining
last portion may be
missing
in FRT
abeyance
portion,
as the
Lord.
main suit is already kept in it.
Last portion. Accordingly, I proceed to dispose of instant miss case, which I had filed for amendment of the issue of right title interest, Your Honor, under Order 6, Rule 7. The learned
Wait. Oh yes, accordingly I proceed to dispose of the instant miss case which has been filed by the earlier seeking amendment of the plain.
Yes.
Learned counsel on the way orally submitted such amendments are necessary as unnecessary. And there are certain amendments
my father expired.
duty. Removing the name of the defendant one suit for declaration of right title one to the perusal of the
Lord, I had mentioned the
You are against which one? You are the plaintiff.
yes, I am the plaintiff. Yes, Lord. My sisters were the defendant here.
Huh?
My sisters are the defendant. And my father was also defendant here. During pendency of the suit, my father expired. On 3rd day of
Why the suit has been kept in abeyance?
Lordship, my amendment petition is pending since the days of 2020, Lord.
No, why is your suit kept in abeyance?
It was kept because the amendment prayer is pending, Lord.
That is the reason why.
That is the reason, Lord.
So you are now challenging the rejection of your amendment petition.
Yes, Lord. 7-2-2020.
Now what is the suit you are asking for?
Actually,
Where is your
in
amendment
the
petition?
original, sir, I asked for perpetual injunction so as to prevent them not to cause any disturbance or nuisances to me in my possession without following due process of law. Unfortunately, during pendency of the suit, my father expired. And what's happened as the act of God is there took place. That's why I tried to amend this portion, Your Honor. Because my father during his lifetime, by open family settlement on 10/7/2024.
Where is your amendment petition?
Amendment. Annexure 5. Annexure 5 is the amendment petition, page number 56.
Annexure?
Annexure 5, page number 56. Page number 56.
What does it? So you want the defend number one to be removed?
I had paid for removal of him, Your Honor. At the
How is
same
it
time,
possible?
because during his lifetime, Your Honor, in the year 2012, Your Honor, he gave me the property, which I have been enjoying since the days of my forefathers. And that property already
Now
in
why do
dilapidated
you want to
condition.
remove defend number one?
Lordship, it can be removed, Your Honor, no doubt. Removal is already done in the year 2020 itself, Your Honor. Because he expired during pendency of the suit. My father gave me the property in the year 2012 itself, Your Honor. I tried to bring that issue, Your Honor, by an amendment, Your Honor.
Now tell me, what is the right title short for?
Right title actually short for in respect of the property in my occupation.
What is the declaration of right title and interest in favor of the plaintiff in
Ye-
respect
ye-
to the suit of?
Yes, Lord.
What is the value of the suit?
Suit is already filed in the year 2019.
So what? What is the value of the suit?
English, it was
Value of the
filed for to
property.
prevent the nuisances. They are causing me nuisances, Your Honor.
You are asking for declaration of a right title interest.
Yes, Lord.
Then if you are
Because
asking for, Mr.
property-
Sharma, kindly listen. If you are asking for declaration of right title interest, then wouldn't that the court fee would be in terms with order section 7(4)(c)?
Yes, Lord. I am
If
ready
it
to
is
give the court fee.
7(4)(c) is the court fee, then the suit have value has to be on the basis of the value of the property.
Yes, Lord. I am
Now,
ready
if the
to-
value of the property exceeds What is the valuation of the Munsif?
Up to 5 lakh. Now jurisdiction is up to 5 lakh.
So, would it remain?
Yes, it will remain there, Your Lord.
How do you say?
Yes, because property is only hardly 18 or 19 lakhs, Your Lord.
Where?
It is at Ulwadi area, Guwahati. Your Lord.
Guwahati 19 lakhs, you get it.
18 or 19 lakhs a year. 18 or, my actual position is in 18 lakhs a year. Though
So-
it is, in document is shown as 1 kotha,
So,
my property is in 18 lakhs a year.
So-
And adjoining plot is enjoying my sister, Your Honor. There is a defendant here. They are enjoying the property. My father during his lifetime gave me the property, Your Honor. And I tried to bring that issue, Your Honor.
how, no, would this court retain the jurisdiction?
Yes, Lord. If jurisdiction is not there, then it can be returned back to the Honorable District Judge Kamrup, Your Honor.
No, you cannot allow an amendment.
Lord,
How can you allow an amendment, thereby changing the jurisdiction? That would, you can't do that.
What you think is that I am ready to give the requisite court fee.
That is immaterial. How do you take care of the pecuniary jurisdiction? You are ready very well. Therefore, you need to file it before the civil judge if it is more than 5 lakhs.
Lord, the thing is not like that. Question of jurisdiction has not arisen, Your Honor. The question is that the very amendment.
I am raising it. Forget about the other side. I am raising it.
Lord, the thing is the learned Munsif Court. has
Learned
come to-
Munsif Court, you are coming before this court. Therefore, I am raising it. If I
I-
allow the amendment, wouldn't that change the jurisdiction?
It cannot change the jurisdiction, Your Honor.
Therefore, can you have a declaration of your right title interest?
Because the issue, I am ready to pay the requisite court fee.
It is not a question of court fee. The jurisdiction as per the Bengal Public Recovery Act, the Bengal Agra the Civil Courts
Bengal
Act
Agra.
makes it clear that the jurisdiction of the Munsif is only 5 lakh.
Yes, Lord. Yes, absolutely.
If it was in the before the civil judge,
Yes.
if this order was passed by the civil judge, then I would not have put this question. But the moment you put the valuation, now you have to put the valuation of the suit, which you have not done that.
No, I have already put my valuation, Lord.
At that point of time,
That one, in the year 19.
then you will put it at rupees 100.
No,
Taking,
100.
how much did you put?
My print is there. Lordship mechanism.
Understood. You won't put it much because it's a suit for perpetual injunction.
Yes, yes.
Then
Perfectly.
now you are having a suit for declaration. Declaration has to be on in terms of the Suit Valuation Act, the value of the property.
I am ready to give the valuation, Your Honor.
If you give, it will go outside the jurisdiction of the court. Why you are not understanding the simple
I have
question?
I have understood, Lord.
That if you give it, it will go outside the jurisdiction, and as such, it will. You cannot make the jurisdiction or take out the jurisdiction from that court. Otherwise, everybody will ask for amendments. Just for example, I don't like this Munsif Court.
Lord.
Why not have it out there in the civil judge? We have got a better judge out there. Then immediately out there, I seek an amendment. I want to increase the valuation.
I am ready to increase the valuation as well.
The
as to
moment
give
it
the
is
receipt.
given, it will go outside the jurisdiction. Can you do that?
Yes, Lordship can give and revert to me, Your Honor.
Well,
I will
what?
do
You
that,
file a
Lord.
fresh suit.
Yes, Lord.
File a
Yes, I will
fresh
file
suit.
fresh suit. No doubt, Your Honor. I will file
Why do you are
a
challenging
revert
this?
may be given, Your Honor. My sequence of events is coming from the day of 19, Your Honor.
Understood.
Question of limitation
You
may
are
arise, Your Honor.
your declaration of right title interest, as well as for what?
For the property which is in my occupation.
Not to disturb your possession.
Yes, not to disturb my.
So you can very well withdraw the suit and file a fresh suit. What is the problem?
think is there a limitation, issue of limitation may arise.
Why?
Because my father gave me the property in the year 2012. I made the references in the year of 2019 also. That references I made. But when my father was alive, I cannot ask for the right to interest. As per Doyabhaga school, after his death, I can claim right to. That's why I have to, after his death, Your Honor, I have claimed for the right to.
So you can claim at any point of time. Is there any limitation for that?
But since the year 2012 is involved here.
So are you? What is the perpetual injunction sought for?
It was thought for not to disturb my position.
So
without following due
is
process.
there a limitation for that?
That limitation is not.
So then, anytime anybody can disturb any point of time. You may have a, just for example, you must have got your father's property, and after getting the father's property, you don't file a suit. Not necessary. After many years, somebody else comes up and says that you look here, Mr. H. Sharma is this my possession. I want to take over. You want an injunction. Now, can you say that you don't have a right of declaration along with injunction?
I cannot.
Better withdraw the suit if you have a problem without this, because now it will go outside the jurisdiction of the court.
At least liberty may be given, Lord,
For what?
for filing this suit, Your Honor, because they may come to a limitation aspect, Your Honor.
Limitation extent, why? How does limitation come into play?
Your Honor, in the year 2012, the property gave to me.
So what?
I made it reference in the year 2019 when I filed the suit, Your Honor. Father
How does
accidentally
it
died in the
matter?
year 2020.
How did it matter, Mr. Sharma? Tell me. Show me in the Limitation Act that it is 3 years. Show me.
Yes.
In a suit for declaration along with the consequential relief for
3
injunction.
years is there, yes.
Huh?
Yes,
Is it 3 years?
yes, yes.
Where? Show me.
3 years is actually from the date of 2012. I am making this point.
Where is it in the Limitation Act? It is 3 years. No, there is no limitation for seeking a
For filing
declaration.
right title interest or
Absolutely no
or to
declaration.
share of the paternal property.
If you now, just for example, you are given the liberty to amend the suit.
Yes.
Why? Why do you want a declaration now?
Because my father gave me the property in the year 2012. Your. I made it as a reference in the year 2019. I filed the suit. Your.
Then also it is beyond limitation.
But thing is that when my father was alive, I cannot claim it, Your Honor, by open right. Your.
Huh?
When my father was alive, Your, he died subsequently, Your, during pendency of the suit. That's why I tried to make a necessary amendment. Your. That is the thing. But London trial court came to a finding that it may change the nature of the suit.
Obviously.
The
And
last
what is the stage of the suit?
suit is at the SBPH stage, Lord.
Trial start.
It is an evidence stage, Lord. On
Then-
18.5.
Then you know
On 18.5, it is an
determine
evidence
the
stage.
issue of right title interest after the death of the father on the basis of the preliminary arrangement established by the year of plaintiff has been clearly amendment. It is nothing but a real controversy in
If the amendment is allowed at page number 68, Your Honor, of the
That-
dispute
if,
order,
let us assume they will allow your amendment, but it will date back only from the date of the amendment.
date of the amendment,
Then also limitation goes.
it may be, Your Honor. It may be allowed, Your Honor.
Then also limitation goes.
Limitation will not come here.
Why? It
Because
will be
your-
taken from only
because
from
matter
today.
is already sub judice. That
So what?
References of his family settlement is already there, Your Honor.
You see, the court, if this court passes an order that the principles of relation back shall not apply, then
Your Honor, not cheap. My point is that, Your Honor, from the days of 2012, I have explained entire things, Your Honor. Subsequently, the relation between the fathers and sons got strained, Your Honor, as well as the daughters, Your Honor. That's why the suit came up in the year 2019. During pendency, Your Honor, father expired. That is the but nature of the suit will remain, Your Honor.
what do you want? Dismissal?
So this may liberty may be given.
For what?
I will file appropriate, Your Honor. Appropriate pleadings before the court bureau
That you are always at liberty.
may be given, Your Honor. The party has come.
The Leonard, Mr. Withdraw you. Should I dismiss? Dismiss, it will have far-reaching consequences.
Yes, maybe.
So withdraw with liberty.
With liberty.
Mr. H.K. Sharma, the Learned Counsel. This is an application filed under Article 227 of the Constitution challenging the order dated 7/2/2024, passed in case number 179/2020, arising out of title suit number 23/2019.
Lordship, I
Miss-
had mentioned 115 of PCO.
Forget about it. The Mr. H. Sharma, the H.K. Sharma, the Learned Counsel, appearing on behalf of the petitioner, submits that taking into account that incorporation of the relief of declaration of right title and interest over the suit property may result in the amendment result in changing the pecuniary jurisdiction of the court. Inasmuch as title suit number 23/19 is presently pending before the court of the Munsif. Number
Number one.
Number 1, Kamrup Metro at Guwahati, whose pecuniary jurisdiction is only up to 5 lakh. The council therefore submits that he would not like to press the instant petition. He, however, submits that the withdrawal of the instant petition should not preclude the petitioner to file a separate suit if otherwise permissible under law. Taking into account the above, this court therefore closes the instant petition on withdrawal. It is, however, made clear that the withdrawal of the instant petition, or for that matter, the order dated 7/2/2024 passed in Mizze case number 179/2020 in title suit number 7023/2019 shall not preclude the petitioner to file a separate suit if otherwise permissible under law. You need to withdraw the earlier one.
Yes.
At the time of filing.
Must be.
I is for
I had one
stay.
I also.
For stay.
It becomes your for stay of the father.
It becomes influx.
It becomes influx.
Yes. What are you challenging?
Input order is case 71 matter.
What is this?
Case 71 matter. Wants to reduce evidence of paternal uncle and maternal uncle.
For allowing the plaintiff to file evidence on chief in the form of affidavit of her paternal uncle Vinod Borua, Arun Borua, and maternal uncle so-and-so, brother of Iman, and government gown. Yes.
Petitioner wants to prove her factor as the illegitimate daughter of late Prince Purdhan Borua. To prove that my lord, his brother of my lord Purdhan Borua, and the maternal uncle of the my lord, brother of the defendant, and the local Gaubra want to use their evidence. They are called family members.
That I have understood. But why did you wake up so late? Why? After everything is over, plaintiff's cross-examination is over,
On the same day,
then you file this.
same day. As the traffic can be allowed.
When did you file this application? On 8/11?
8/11 on 8/11 was processed.
Hello, or Mr. H.R. Ahmed, the learned counsel appearing on behalf of the petitioner. This is an application under Article 27 of the Constitution, challenging the order dated 23/2024, passed in title suit number 03/2021, whereby the petition number 1596/2023, dated 8/11/2023, has been rejected by the learned trial court. To notice, making it returnable on 19/6/2024. Steps be taken by way of registered as well as usual. In addition to that, the petitioner is also directed to take steps by way of the stay routed to the registry of this court and file an affidavit of service on or before the next date. This court, having taken note of the order which has been passed, order which is impugned in the instant proceeding, and the submission of the learned counsel for the petitioner to the effect that the said application was filed on the date on which the evidence of the plaintiff was disclosed on account of the completion of the cross-examination, is of the opinion that the said respect, the legality of the order dated 23/2024 has to be looked into. Taking into account the above, this court stays further proceedings of title suit number 3/2021 in as much as allowing the proceedings of the said suit to proceed during the pendency of the instant proceeding would be an abuse of process. Accordingly, title suit number 3/2021 stands state pending before the Court of the Civil Judge Senior Division, Sibsagar, stands stayed till the next stage. Yes, Mr. Sikdar.
My lord, I am against the input order, but find at
Page
91. But would file a suit under 60 relevant as the suit was said expert of duty serving notice, then execution they have not turned up. My lord, therefore, my lord, they have filed a petition for vacating the expert order with a false condemnation.
so delay was condoned.
Bill was condemned, that petition is false.
Why?
My lord, kindly have a look at my lord, their petition, condemnation petition. At page 72, my lord,
Page?
relevant portion at page start from 71 and relevant portion 72. Para 3, my lord. They have stated that they came to know about ex parte order only on 27/9/2022.
22/9.
But 27/9/2020, where there was a notice was served in my lord title suit, then execution. They have appeared in the execution petition by filing Bolantabad. Bolantabad have also annexed.
When did they file it in the execution?
My lord, execution. My lord, execution. That notice was issued in annexer 10.
They appeared in the title suit.
Not appeared in that.
Then
My lord, in the execution petition they have appeared. They could have raised everything in the execution petition, and they have.
no, this is dated 14/9/2022.
My lord.
And then
My lord, execution petition is at page 51. It was filed on 21/1/19. Execution petition, and notice was issued. They have turned up.
Huh?
No, in execution petition they have appeared. File a petition.
when?
My lord, they have appeared, my lord. Kindly have a look at my lord the order dated 18/2/2019, page 62. They have appeared and filed
Page
petition
50.
62, my lord. On 18/2/2019, the advocate for the judgment debtor filed petition by number 3690 for time for filing written objection. There was allowed. They have not filed any written objection.
Where is that petition?
Well, their condemnation petition, Lord, you will find.
No, where is that petition? That order
That
petition
petition-
filed on certain. Because the Wakalatnama is dated 18/2/2019.
My lord, their petition. My lord, at page 58.
Page,
Vernacular is not annexed, but we have translated to paper. No, vernacular is at page 60.
where's your objection?
My lord, objection petition, Lord will find. Objection to their petition. My lord, it's at page 85. My objection petition against their condemnation. And their condemnation petition, we have stated everything that they have received notice and appeared, filed. They have taken time for filing objection. How it false statement and submission of fact can be undertaken.
Now, what has happened to your execution?
The execution has been, my lord, executed, my lord. The
Sale deed executed.
Sale deed has been turned mutation also. It has attained the finality.
Or Mr. A.R. Tikar, the learned counsel appearing on behalf of the petitioner. Notice making it returnable by 21/6/2024. Steps be taken by way of registered as well as usual within 3 days. In addition to that, the petitioner is directed to take steps by way of justice, receipt to the registry of this court and file an affidavit of service on or before the next day. So this is an application challenging the under Article 227 of the Constitution, challenging the condonation of delay by the learned trial court, that is the Court of the Civil Judge Senior Division, Gwalpar, in Mizze case number 88/2022, arising out of title suit number 21/2016. It is a specific case of the petitioner that the learned trial court, while passing the state order, failed to take note of that in the execution application, the respondent herein duly participated in the year 2019. However, at a later point of time, the said respondents did not participate in the execution proceeding. And in the meantime, and for which the executing court further proceeded with the execution of the decree, and and accordingly, the decree has already been executed. These aspects of the matter were not at all taken into consideration, which was duly pointed out in the written objection so filed against the application seeking condonation of delay. So taking into account the above aspects of the matter, this court is of the opinion this is a fit case for examination of the legality and validity of the order dated 5/2024, which have been impugned in the instant proceedings. Accordingly, this court therefore stays the further proceedings of title suit number 21/2016, further proceeding of Miss case number 83/2022, arising out of title suit number 21/2016, or for that matter, we state that title suit number states the further proceedings of title suit number 21/2016, as along with any miscellaneous applications filed therein till the next date.
Biplab.
25. Yeah.
For? 17.5 for
Argument. Argument.
issue notice making it returnable by 21/6/2024. Step be taken by way of registered as well as usual on the respond. For the respond number 1, this court is not inclined to by registered post on the respondent. So in addition to that, the petitioner is also likely to accept by way of the state on the respondent. Taking into account the matter, taking into account the present proceeding, this court is not inclined to issue notice upon the respondent number 2 and 3, who are the owner and the driver of the vehicle. The case of the petitioner herein is that the petitioner, which is the ICICI Lombard General Insurance Company Limited, on the basis of a demerger proceeding, had acquired the assets and liabilities of Bharati Exa
Bharti Exa.
General Insurance Co. Limited in the year 2000
21.
in the month of
5/9. September
on
20.
3rd of September 2000. Therefore, it came to the notice of the petition about the pendency of the instance for which an application was filed for vacation of the ex parte order passed on 28/2/2022.
23.
Hmm?
To 28 to
28/1/2022.
22 Lordship.
28
Two.
Is 21/22 or
Lordship,
38?
Page number 34.
28/2/2023. The learned counsel for the petitioner so submits that the state application does not contain the required particulars. Be that as it may, it submits that in absence of the insurance company to avail the defense, it would be grossly prejudicial to the interest of the petitioner company. He therefore submitted that the order dated 28/2/2023 as well as 5/3/2024 ought to be interfered with, taking into account that the claimant have only proceeded against Bharati Exa Life Insurance Company, that General Insurance Bharati Exa General Insurance Company Limited, and not against the appellate petition. This court, upon hearing the learned counsel, is of the opinion that the order dated 28/2/2023 as well as 5/3/2023 requires to be looked into by this court in the present proceeding. And as such, this court states the further proceedings of MSC case number 436 of the 2022 pending before the court of the learned MSCT Borpeta, member MSCT Borpeta, till the next date.
Much obliged.
Yes, what is this?
Petitioner lordship has till the order dated 2/3/2024 as well as
Page.
page 36. Reported lordship,
Yes.
yes, so on that date, lordship, the case was fixed for cross-examination of the W lordship, and the petitioner reported lordship, who is the wife, the respondent, lady lordship, could not appear because of her ill health, lordship. And she asked one of her known advocate to submit a petition before the learned, adjourned petition before the learned court, lordship. And accordingly, the advocate lordship sought for the case date, because in the court service lordship, the parties could not be affected. So the petitioner has forwarded an application of which she was earlier earlier that submitted the court below, and that advocate lordship submitted that petition. After the court was pleased to reject the petition, and the case was fixed for DW by the cross-examination of DW has been dispensed with, lordship. Thereafter, at page 38, lordship, on the next date, lordship, 10/4/2024, lordship, the petitioner has filed a petition to recall the order dated 3/24, which allowing her to cross-examine the PCW. But on the same day, lordship, the Senate Court lordship has rejected her petition and it was for DW. It is also to be further submitted, lordship, that the evidence of the PW lordship are filed on 2010/2022 lordship at page 27. But lordship, the respondent herein and the husband lordship, though he has filed the evidence lordship, he has not served a copy upon the petitioner lord, which is evidence from the order dated 17/8/2023 lord, page 32. Whereby lordship, the specific direction was given to the petitioner, to the husband, to serve the copy. But despite of the order lordship, order dated 12/5/2023 at page 30 lordship, the petitioner has not, the husband lordship, respondent herein has not provided the service copy of the evidence of an affidavit for which the prosecution could not be conducted.
What?
The service copy, the copy of evidence copy served of the partnership, that copy has not served.
You were absent on 12/5/2023. How can it be served?
Lordship, evidence was filed on 2010/2022 lord.
What is 17/8/2023?
Yes, 17.
Petitioner husband has submitted his additional evidence. A copy of the same is furnished to RIA. Opposite party has filed a stating that in spite of specific directions, the RIA has not furnished the RIA and she is not in a position to go for RIA. And the petitioner has furnished the copy. See, on this,
Yes,
the petitioner has furnished the copy. Then why are you making all this type of submissions?
lordship, on 17/8 lordship.
Understood.
Yes.
17/8 it is being given. Then
Yes, lordship, page 33 lordship. Next.
Then?
On that day, lordship, due to waterlogging, both the parties sought adjourned before the learned court below.
Then
And on the very next day, on page 34 and as well as page 35, the order dated 12/2 and 19, the PO is transferred lordship. So the cost is deducted. On 19/1/24, page 35.
Then
On that day, and thereafter the case was 6/1/24.
What was your medical certificate? Why didn't you enclose the medical certificate when you filed that application?
That has not been done
Then?
because
Oh.
the copy of the medical certificate has been provided, Lordship. He has not got the, as per her statement, Lordship, he has provided the original one. But
To,
the petitioner did
to,
to the court, but he has not annexed the medical documents along with the petition.
are you making a statement that the petitioner had given the original documents to the court
No.
and the court have
No.
said that the medical documents are not there?
No, Lordship.
Then why are you making that statement?
Okay, what I'm trying to submit is that on that day he has not got the Xerox. When court has asked, he said, I have the original copy which he wants to he handed over to the court, but court asked her to submit a Xerox copy, but he could not submit that Xerox copy.
Why?
So Lordship,
No Xerox machine is
there-
available
there
in
is-
Guwahati.
There is Xerox machine, Lordship, but that fact, Lordship, I am so not sure because Lordship, he had to went all along to the court. Lordship.
What? Show me a medical document that on 2/3/2024 you had any problem?
Lordship,
Any medical document that 2/3/2024 you had a problem?
on 2 no, Lordship, on the previous date, Lordship, and thereafter also, Lordship, the medical, some of the medical documents have been, Lordship, in with her at her native place.
Hmm.
So I could not submit.
Then you can't submit. Then if you could not submit before the court, you couldn't submit here. Then
Lordship,
why should this court at all interfere?
but Lordship, the medical documents of are earlier are
Mr. Counsel, kindly understand, if this court keeps on interfering with these minimal dispute, small things, then what is left? Nobody will care the trial court.
that I
Then?
but if I could not process them with the
That is your lookout.
I
You have
advocate
been
will be
given enough time.
initiated, Lord.
You have to be very careful. You have to be careful.
If the one thing may substitute that the petitioner before Lordship has also filed her principal within time motion. She is very she is willing to cross-examine the
So?
for proper assessment of the case.
Why?
That is to be
Why should this court at all interfere with all these things? You have been stating that, oh no, you are going back out there saying that I have not received the papers and all these things. Why should this court at all interfere?
Lordship,
We are exercising 227. We can't exercise 227 just at drop of the hat. Then
that I understand, Lordship, but one thing kindly consider that copy of this, if the Lordship, the
copy was given on 17/8/2023.
yes, Lordship, but thereafter, Lordship, on 6/10, Lordship, due to waterlogging, Lordship, the
Waterlogging, what is there with the copy?
no, Lordship, for that reason, the Lordship, court parties could not appear for the 94 below, Lordship.
Then
And thereafter, Lordship, the court of state transferred. On 2/4, Lordship, apparently, there is a one document, Lordship.
how has court of transfer when the witness is present in the court have anything to do?
Lordship, the PPO is transferred, Lordship.
On 2/3, the court was very much
Yes,
present.
on
Then
2/6, court of
then-
state, Lordship,
there is no medical documents also. The court has also observed that there is no medical documents.
Lordship,
And you make a submission that you have given the original and the court have asked you to photocopy.
no,
And those documents you are enclosing and none of these documents shows.
no,
These are only, sir, prescriptions of an ECI hospital.
Lordship, kindly peruse page 40.
Don't come up with all these things. I've looked into those documents. Those documents are not documents of medical.
Yes, undergone a heart treatment, Lord.
Who
The petitioner referred to, Lord.
has undergone?
A heart treatment, Lord.
When?
On Lordship, 22 and
So 22. Now, how can you, on that date, you had some problem out there, then it would have been a different thing.
Yes, Lordship, that the petitioner, Lordship, sometimes Lordship has this problem. Lordship.
What?
The impure lordship, this pain lordship. The husband is also very much aware. Lordship. Both the parties are staying in the same house.
Huh?
Both the parties lordship are staying in the same house.
Then
Husband is also very well aware of the fact. So, lordship, if I could not cross-examine the husband, lordship, our entire family would be the subject of
it's a suit for what?
for decree of divorce.
So good.
Lordship, I don't want a decree of divorce, lordship, because
Why?
I have a son, lordship, and my son also does not want the decree of decree, lordship, as well as
So
the-
give your evidence. You have been permitted to
If-
give
if-
evidence.
If I could not cross-examine lordship, then lordship,
You are going to cross-examine. You.
But-
Are you going to do the cross-examination? Who is going to do? The lady.
no, lordship, either she will have to appoint some amicus curiae. I don't know whether she will appoint me or
So then,
lordship, the also lordship in my petition, so the in fact the brother, the elder brother as well as younger brother, as well as the mother of the respondent husband, they also does not want to be to that the both the parties got separated. The wife of the respondent is staying with the petitioner also. Till death. She is taking care of her in-law family.
who
The petitioner for your lord.
is taking care of the in-laws family?
Yes, lord.
So it will be a loss to them
Lordship,
if you
yes,
are divorced.
yes, lordship, that is the only reason, lordship, her in-laws does not want her to get the decree of divorce.
So you want to cross-examine that.
Yes,
You give your evidence.
lordship, if I don't go the process, lordship, then the evidence filed by the petitioner will be accepted. Lordship.
Not satisfied, Mr. Counsel.
Lordship, one
When is the next date fixed?
tomorrow, Lord.
Sorry, not satisfied. You give your evidence. I'm not satisfied.
One question, lordship, cross-examination based on the pleadings, lordship, because otherwise, lordship, the petitioner will suffer equal loss, lordship.
It happens.
That will prejudice, lordship, to the petitioner as well
So
as
what?
her entire family, lordship.
Hello, let me dismiss this.
Lordship,
I'm not satisfied.
lordship,
Why did you file it on 13th of May?
Lordship, because the certified copy of the order has, I have obtained a certified copy of the order on 13th of May, Lord.
When did you apply?
Applied on, lordship, 5th of May, Lord.
Then why did you apply on 5th of May of 10th
Lordship.
of 10th of 10/4? You enjoying a bihu?
No, lordship.
Then?
Lordship, on lordship will, for that, lordship, for a moment, lordship will, find, lordship, my, one,
Why didn't you challenge the earlier order?
earlier order, lordship, when the order was passed, lordship, the petitioner was not aware. After that, when, she entered for the next date, it came to her knowledge the case.
You said on the next date only you filed that
Yes,
application.
yes, lordship.
Then you are
No,
not
no,
aware. Why did you say?
No, on 2-3, lordship, she was not aware.
Mr. Counsel, I am not satisfied.
Lordship, for a moment, lordship,
Chalo,
Perus,
this
lordship,
is
Perus,
dismissed.
page 49, lordship.
I am not satisfied.
Lordship, for a moment, page 49.
No, no.
Lordship,
This
page-
court
page-
is not going to exercise
for
scrutiny.
one last, kindly
Sorry.
page
Lago,
49, lordship,
this is an
for a moment.
application challenging the order dated on one hand, you say that you are supporting the plaintiff's in-laws.
No, lordship.
Whom are you supporting?
I am supporting my in-laws, lordship, except my husband, lordship.
So you are supporting,
And my,
you
and
are, therefore you are supporting your in-laws,
yes,
which means your husband's relatives,
yes, my husband.
and taking the money from the husband.
No, lordship.
You are saying about the 20,000.
Yes, lordship, that 20,000 was maintenance.
Then you are taking the maintenance
No,
from
only-
the husband and then helping out your in-laws.
lordship, no, I am helping my in-laws by my household work, lordship. My household, not financially, in fact, my in-laws are helping my, providing financial aid to my son for his studies, Lordship. My,
So very well. They will obviously forget about the in-laws. Your husband will do because
no,
his
Lordship,
son.
no, Lordship, the husband after my son has completed his class 10 standard board exam, Lordship, my husband is not paying any amount to my son for his studies and other expenses. Lordship. It is just my brother-in-law, my elder brother-in-law, and my younger brother-in-law, Lordship, who are paying the expenses of my son's education, Lordship. And it is my mother-in-law, Lordship, who is providing us, Lordship, food and shelter, Lordship.
Where is your statement made to that effect in your petition?
Yes, sir.
Where?
Yes, sir. Yes, I have categorized that route. The paragraph 13, Lordship, page 10, Lordship.
No, where about the in-laws?
In-laws, Lordship, in my petition for recall, Lordship, on there also I have categorized that page 38, Lord.
To notice making it returnable on 19th of June. Oh, the husband is in the same house.
Yes, Lordship.
Then you should notice making it returnable on 27th of May 2024.
Lordship, till now, at present, the husband went to work at school, Lord, but his place is
He'll come on Sunday.
Maybe.
Praveen, you should notice making it returnable on 27th of May 2024. Steps be taken upon the sole respondent by taking into account that the address mentioned of both the petitioner and the respondent is one and the same. This court directs the petitioner to take steps by way of trustee routed through the registry of this court and file an affidavit of service on or before the next day. Today is 16, nah? Let's have it on
15, Lord.
15. Let's have it on 29th. 20. This is an application filed under Article 227 of the Constitution, challenging the orders dated 2/3/2004, 24 as well as 10/4/2024, whereby the petitioner has been debarred from cross-examining the plaintiff witnesses on the ground that the plaintiff failed to appear. Plaintiff failed to appear on 2/3/2024 when the witnesses were duly present. Further to that, the petitioner also filed an application for recalling of the said order by the learned trial court. However, the said application has also been rejected on the ground that the plaintiff did not produce any medical documents. This court have also taken note of the medical documents which have been placed before this court, from a perusal of which it appears that the petitioner is a highly diabetic. And the learned counsel appearing on behalf of the petitioner duly submits that the medical documents could not be placed on the earlier occasion before the tribunal, but before the learned court below. However, he submits that from a perusal of these documents would clearly show that the petitioner is a highly diabetic, a diabetic patient, and has also various other comorbidity diseases. Taking into account the said medical documents, this court is of opinion that the in order dated 2/3/2024 and 10/4/2024 may require may require an interference. Under such circumstances, this court have therefore issued notice in the instant matter. This court further, taking into account that the orders dated 2/3/2024 and 10/4/2024 is being presently adjudicated by this court, stays the further proceedings of suit number FC civil case number 138/2019 pending before the court of the principal judge, family court number 3, Kamrup Metro at Guwahati, till the next date. Take your survey steps and don't come up as I have not been able. If necessary, go to Tejpur.
Item 9.
Yes, what is this?
The cost was imposed upon the respondent for paying for the court.
What is this?
Annexure A, page 12. Paragraph number 33, page 27.
19/10/2023
Yes,
is the order.
yes.
Then
Page 27, paragraph number 33.
going to the fraud being practiced upon the you notice you have not, they have not deposited. You notice making it returnable. On 24/6/2024. Steps be taken by way of registered as well as usual within 3 days. In addition to that, the petitioner is also directed to take steps by way of dusty, rooted to the registry of this court and file an affidavit of service on or before the next day. The instant contempt application has been filed on account of non-compliance to the directions passed by this court at paragraph number 33 of the judgment and order dated 19/10/2023, passed in CRP number 166/2023. The said paragraph number 33 is reproduced herein below. From a perusal of the said paragraph, the directions passed in the said paragraph quoted herein above, it would be seen that there was a direction being given to the opposite parties herein to deposit the cost of rupees 50,000 before the court of the civil judge senior division number 1 in title suit number 397/2021 within a period of 1 month from the date of the said order. It was also observed that in the circumstance such amount is not being deposited within the time allowed, the respondents who are the petitioners herein can take steps in this court for enforcement of the award cost. Taking into account that there has been a Mr. S.R. Gogoi, the learned counsel appearing on behalf of the petitioner, submits that the said amount had till date not been deposited before the court of the civil judge senior division number 1, Kamrup Metro, Guwahati, in title suit number 397/2021. Under such circumstances, this court has therefore issued notice It is, however, observed that pending notice, the opposite parties herein would be at liberty to deposit the said amount before the learned trial court as directed in the above mentioned paragraph of the order dated 19/10/2020. They will deposit now.
Made with the Lordship.
Hmm.
I'm aggrieved by the order. This is 18/4, 24, page 97.
What are you challenging? 18/4. 18/4,
18/4,
page 99.
page 9. Page 97, the order starts.
What are you challenging?
Page 97, the order. 18/4 to 20, page
Hmm.
97. May I read it?
Yes, what is wrong with this order?
Your Lordship, the court, Your Lordship may kindly peruse page 98, paragraph 5.
What is the injunction you are asking for?
This should be restrained.
From
Your Lordship.
entering into the suit land fully described in Schedule A to the and restraining
Lord.
them from disturbing the peaceful possession of the petitioner over the Schedule A land.
We are the owners, Your Lordship. We are the owners of the possessors. They came and they broke the boundary wall, Your Lordship. We have got photographs also annexed, Your Lordship. Kindly peruse page 78, 79 are the photographs.
For me, your injunction application,
Starts at page 80.
page,
It starts at page 80.
why after the police have taken step, why is it necessary you for an injunction?
Because we apprehend that they may again come, Your Lordship.
Why?
They may again come and break the wall, Your Lordship.
Why?
They are complete strangers, Your Lordship, but what we page 80.
Where is your injunction application?
Page 80.
Page?
82. Starts at page 80. Page 90, paragraph 10, Your Lordship.
Have you taken steps in the suit?
Yes,
When?
on the very thing, not next week.
What is the state of the effect of the service?
Pending.
How?
Good
Why?
thing.
Why is it pending? Because of why I'm saying so. Because you filed this appeal now. Order was passed on 18/4. 18/4.
18/4.
18/4. We are almost a month. You must have filed it 2-3 days back.
A week back, Your Lordship. 3/5.
Huh?
3/5.
3/5. Now, after that, you want an injunction. Why?
What I paid Your Lordship may protect me till the next day, Your Lordship, and
Why?
till 6, because I apprehend, Your Lordship. They may again
No, no,
come.
you have to say what is your apprehension after that.
They may again come and break the boundary wall, Your Lordship. Because
Understood. But the fact that nothing has happened thereafter,
true, Your-
you have to make a statement in your injunction petition.
I had, Your Lordship.
Where?
I had, that is why
No, in this petition, before this court. Where is your statement after that order? What? Where is your statement? There is no statement.
the grounds I have stated, Your Lordship.
Huh?
Statement, yes, sir.
Where? That after the order, they have taken any steps? No.
No.
Then, how do I help you?
Okay.
You have to make a categorical statement that, look here, even after that order being passed, there is a serious threat to my possession. There's not a single statement. You are saying that court is wrong.
Your Lordship.
That is what I am looking into, the IA. Where is it? Do one thing. File a small, short affidavit stating that aspect. That even after that, if it is true,
Yes.
otherwise no. Mr. E. Deory, the learned counsel appearing on behalf of the petitioner, submits that even after the order being passed by the learned trial court, not granting an ex parte injunction, there has been certain disturbance. However, the same does not appear from a perusal of the interlocutory application filed for grant of an injunction. The learned counsel submits that the same aspect of the matter would be brought on record by filing an additional affidavit. Submits that the said affidavit be filed tomorrow, taking into account the urgency expressed. Let the matter be again listed on 17th of May.
Yes, sir.
You need to. It is not an appeal. Appeal is okay, but you have to let us something.
I understand. Okay, so-
And also find out whether service is done or not.
Yes, Your Lordship. I will.
Yes, Mr. Counsel.
Lord, there may be called for.
Why?
There is, Lord, a copy of the plaint matter.
What?
In the plaint copy, Your Lordship, something are invisible. So I could not make sense type properly.
What? What is a substantial question of law? LCR may be called for. Why will you call for LCR?
Then Your Lordship. Yeah.
These are the
Question number 2 and 3.
you are a plaintiff. What is your suit for?
It's 76.
Plaintiff is not here.
Plaint. Plaint and Lordship.
Where?
page 70, Lordship, original print is there. Prayer is for a decree for declaration of right title interest over the suit as shown in Schedule B. A decree for declaration that the defendant number one has got no right to sell, mortgage, or transfer the.
You have not challenged the sale deed. Why will it be cancelled?
Tell it is challenge matter.
Where?
Then was made amendment.
For declaration that the defendant number one illegally executed the registered sale deed in favor of the defendant number 2 and 3, and so and so. A decree for class possession by evicting the defendant number 2 and 3 from suit land by demolishing the houses and other structures in the decree for declaration of the illegal registered sale deed. So everything is on that sale deed, whether defendant number 1 had title or not.
Right.
That's all the question. Revolves everything. How does the trial court look into that? Let's see the trial court judge. First appellate court. Trial court judge. This is a suit for permanent injunction. Who is Ishak Mia?
Sakya is the father of the plaintiff.
There is an earlier round of litigation. That judgment is also an expert.
Understood. Who is Ishak Mia is the father of the plaintiff.
Sure.
What has happened in the earlier suit?
There was a direction that if he files any suit declaring the defendant as a tenant, that may be taken into and considered in that suit. Lord.
Huh?
Lordship, that part I am reading page 75. The clear direction is there.
Yes. Whether the defendant is a tenant,
Tenant.
the
Lord.
suit land. Defendant was Duga Mistry. Duga Mistry's son is the defendant number 1.
Yes, Lordship. I have purchased from.
And 2 and 3 are the purchase.
Lord.
how did the defendant sell?
Lordship, defendant's case is that, Lordship, he has purchased the tenancy from one, Lordship, from the wife of Muhammad Ali Khalifa, on whose death
Who was
he,
also a tenant?
yes,
That, these are understood.
Lord.
But how did the defendant execute the deed of sale to the defendant number 2 and
Lordship, during pendency of this case. And we have no information that this case is pending. Lord, 2005 title suit was filed by the
I'm not
plaintiff.
on that. Can a tenant make the deed of sale?
Lord, he has already told Lord, his name was there in the record of right. So we are under impression that he is the owner of the suit land. Lord. We are not aware about
No, no,
the-
that I'm not concerned.
Lord.
First question is as to whether being a defendant number 1,
Lord.
status being that of a tenant,
Lord.
would have transferred by way of a deed of sale the right,
It
title
is
and
not-
interest over the land to him. Yes, there might be a transfer of the possessory right. It's a different aspect. I'm not on that. But can there be a deed of sale of transferring the right, title and interest unless the government confers occupancy rights or the ownership rights?
Lord.
Whether the defendant number 1 was granted the occupancy rights?
that we have no.
Yes, Mr. Counsel, I'm trying to help you. You help this court something. Whether the defendant number 1 have been granted the occupancy ownership rights in view of 23 and 25. Because he was a tenant under the 71 Act. 71 Act,
I'm the
He is the
landlord.
owner, defendant number 1 is the tenant, Lordship. My vendor is the tenant,
understood.
Lordship.
Defendant number 1 was a tenant under the 71 Act.
Lordship. And he has also filed his written statement that is annexed by this appellant, Lordship.
Hmm.
Page number, Lordship.
He, however, states that as and when the suit is filed, the court shall have to decide whether the defendant is protected from eviction under the provision of Assam Urban Area Non-Agricultural Tenancy Act.
But Lordship, defendant
If it is
number
a non-agricultural tenancy act, he doesn't even have the right of khatiyan and ownership, which cannot be granted to him.
defendant number 1 stated that in page 56, Lordship, annexure 3.
What is the right of the defendant to make the sale?
Para 7, your Lordship, page 56.
Let us see how the trial court have decided all this. I will be cancelled. Guwahati High Court.
In fact, Lordship, periodic patta was also issued in favor of the Durga.
How? Occupancy tenant shall have permanent, heritable, and transferable right of use of the occupancy in the land of his holding subject to other provisions. Where is the land?
Dhubri
Dhubri where? Dhubri town.
town, Lord,
Then, if it is Dhubri town, how the 1971 Act will apply?
urban area.
That is what the second appellate court had held. And if it is there, how do you get a title over to sell, execute a deed of sale? You can't get a
19
periodic patta or anything to that effect.
In para 7, defendant number 1 stated that on the strength of sale deed number 7 dated 54, Lord.
Huh?
Para 7, page 56, your Lordship will find.
No. The instant appeal heard Mr.
Yeah.
A. Rahman, Villain Counsel appearing on behalf of the appellant. Appellant or appellant? Appellant. And Mr. Why there were 2 appellants earlier and 1 appellant now? Anyway, and Ms. R. Chaudhary appearing on behalf of the respondent number
2 and 3.
2 and 3. So this is an appeal directed against the judgment and decree dated 21/3/2022, passed in title appeal number 36 of the 2018, whereby the appeal was dismissed, thereby affirming the judgment and decree dated 11/7/2018, passed in title suit number 26 of the 2005 by the learned Munsif number 2 Dhupri. Full stop. The instant appeal is admitted by formulating the following substantial question of law.
Have given the paper.
Whether the what you have given is no use. Whether the learned trial, the court below were justified in coming to the conclusion that the defendant number 1 had a saleable right to transfer the suit land in favor of the defendant number 2 and 3, as admittedly the defendant number 1 was a tenant, as could be seen from a perusal of the judgment and decree passed by this court dated 30/1/1984 in essay number 207/1977. Number 2, whether the learned courts below had committed perversity, whether the findings arrived at by the learned courts below suffers from perversity in deciding the suit by taking into account that the defendant number 1 was a tenant under the Assam Temporarily Settled Area Tenancy Act 1971, though the suit land was situated in the Dhubri town, wherein the Assam Non-Agricultural Tenancy Act 1955 would have been applicable, and so was held by this court in the judgment and decree dated 30/1/1984 in essay number 207/77. Full stop. Taking into account that the respondent number 2 and 3 are duly represented, no further steps is required to be taken. However, extra copy of the memo of appeal be served upon Ms. R. Chaudhary during the course of the day. As regards the respondent number 1, steps be taken by way of registered as well as usual within 3 days. Full stop. The registry is further directed to call for the records from both the learned trial court as well as the first appellate court. List the matter immediately upon service of notice upon the respondent number 1 and receipt of the LCR. You have a very good case. Get the records ready. Yes.
She wanted to see the evidences.
What is your case?
The case is that I was a defendant. The
Hmm.
plaintiff filed the suit alleging that we have tried to dispossess them. And we have mutated our name illegally, the plot plan. What had happened that was an external land. Where our case is that where the external land, where the two brothers beside. After the death, my lord, their legal heirs, my lord, my cousin, they will not got their name muted. Thereafter, there's a family settlement, my lord, where our names will also entered in Jamapat. Now, the suit has been filed saying that subsequent, my lord, inclusion of a name, my lord, mutation of a name was illegal, my lord, and that was done behind their back. And my lord, we are trying to dispossess them.
Then
My lord, then my lord, the suit was decreed in their favor, but saying that my lord, they've been able
where's
to,
the plane?
my lord, plain lordship will find my lord at page number 6, my lord. The total land, my lord, about 12 bigha, my lord. 12 bigha, 14 lecha. And my lord, the dispute is with regard to my lord, 7 bigha, 3 kota and 5 lecha. There are my lord, 5 my lord, dark, my lord, out of which my lord, the disputed land is in 2 dark. Dark number 26 and 250. Which, according to them, my lord, we have my lord, got our name mutated illegally behind the back. In fact, my lord, the name of the plaintiff's mother was also mutated along with us. She is also a plaintiff, the plaintiff number 3.
Who are you?
We are the my lord, cousins, my lord, of the plaintiff. Our father, my lord, Mathura Kolita, and their father, Gondoru Kolita, were brothers.
Brothers. What land is this?
But subsequently, they claim my lord, they paid premium, my lord, and it was my lord, paid at that name, my lord, the patta was not exhibited.
Both bags are under Kiras Periodic Patta number 139.
Yes, my lord. Subsequently, premium, the plaintiff's claim is that they paid the premium, my lord, and their name were muted.
But you don't have the names in the periodic Patta.
Subsequently, my lord, our names were included, my lord. Periodic patta was not exhibited, but the Jomapandi copy was exhibited. Subsequently, our names were also included, my lord, in 1995. And we say that there was a settlement
In that Patta.
in that patta. There was a settlement among
How?
us.
On
There
the
was
basis of some settlement.
settled.
Then they challenge that mutation.
They challenged this mutation in 2015, saying that in 2015 we tried to dispossess them, and then they came to only then they came to know about the mutation. But you will find in the plain, my lord, that
Why you are saying about the annual Patta?
annual patta, my lord, we are saying that we were my lord, both the brothers, my lord, Gandhuru Kolita and Mathura Kolita, they were my lord, enjoying the land together. But subsequently, when my lord, they made the patta, my lord, prepared the my lord, patta in their name, my lord, they entered their names, my lord, they did it on their own. Subsequently, our names were brought under settlement.
When was the suit filed?
Suit was filed in 2015.
Did you take the plea of the suit being barred?
Lord, we could find our statement
Yes,
at
we have taken.
page 15. Taken.
Now, how does the trial court look into that 154?
The trial court framed the following. Lord, we could find it at page 37. Barred by
Because
law.
they are primarily cases of as regards a mutation,
Right.
which is a land record. The record of rights cannot the civil courts bar. How
Right.
does the court look into it?
Because basically on the point of repetition, that was discussed, law of repetition. But that aspect, my lord, of course, was also not dealt with by.
Because everything revolves around the mutation.
Everything about the repetition.
Then why that issue was not framed?
That is was not framed.
Then well, there is no quarrel with the proposition that they have the Kiraspatta for which they have a right. Unless you prove that there was a mutual understanding on the basis of which it is there. What did you prove?
There also no issues. It was not even discussed. Even the plaintiff, my lord, in his evidence, lastly he says, I do not know what is there in the in my evidence.
Forget about the plaintiff, but it is you. He has a document of title.
Mine.
What did
So
you
it's
do?
an oral settlement. I say it's an oral settlement.
Oral settlement by how?
My lord, it's a family.
Unless
settlement.
you show
Ma'am.
that you had some title over that property
My lord,
earlier.
our case was that, my lord, we were residing together. My lord, our parents were residing together. And after that, my lord, they somehow got their name mutated. And when, my lord, we came to know about it, they also muted our names along with their own mother. The plaintiff's mother, she is the plaintiff number 3. Her name was also mutated along with us. But now they are saying that, oh, this was done behind their cases, it was done behind our back. Only in 2015, when we were trying to dispossess them, that's their case, that they came to learn about this order. They were not aware of it. So they are denying that. But my lord, our case is that we were, my lord, there was a settlement, family settlement, and on the basis of that, my lord, we were in possession of the land.
You see, this court intends to remand the matter back to the trial court by condoning the delay.
Right.
50 days delay ought to have been condoned. But for that, you give me something to say something about the substantial question of law. How to frame a substantial question of law? As of now, there's nothing. The insertion of your name
Right.
on the mutation could not have been made when the patta is being given to somebody else. That is absolutely incorrect.
But my lord, this is the issue of the settlement. It was not at all discussed. Even neither of the parties went into the issue. They don't even introduce any evidence on that. Though we claim
You
there was
raised
no
that
denial.
issue in your first appeal under 104
Well,
or 105.
One people the first appeal method,
Was that your grounds of appeal?
that of course, the memorandum of appeal method. Justify the memorandum of appeal 60.
60.
60. That of course was not specifically taken, but that it was done. It was done in 1995. That remained kept for 50 years. But the thing was taken.
That point is not there.
But since it's a flood that was this was the ground of default, perhaps
Huh?
since this is the ground of default,
Which one?
the first step, this is for on the ground limitation.
But then also you have to have
But as
your grounds of protection in the first appeal. You have not taken that.
general ground melody any view of the matter, while at the time of argument, we could have taken the plea matter.
You can't. 3 out of 41 rule 3.
Any view of the
You
matter
can't take it unless you amend it.
that is also there. But I have amended.
You would have amended it. Have they been clever? Like they pointing at the end of the. You give me something. I am in your favor of setting aside the order of the learned trial court.
Well, I sufficient will be
But give me something.
I sufficient will say the delay is control matter. Then it's remanded back, then
Understood, but question of condemnation of delay, give me something for that. You see, if you see the 2001 Supreme Court judgment, when an appeal is dismissed on the ground of condonation of delay, it amounts to confirmation of the judgment and decree passed by the trial court. So the question of law I have to frame has to be based on that particular aspect. That the learned judgment of the trial court is wrong. Give me something. You have not given me anything.
But here, what has happened, Melody, in this case, I find Melody, the plaintiff, he claims, he, so far as his claim is concerned, though in the suit, he claims that
You see, first of all, the plaintiff has a document of title. Periodic patta is a document of
Patta has not been made. Only the Jamamandi records have been produced. Patta has not been produced. That is evidence that even if it is there, I have not executed it. That is not even on the pleading matter that is there. But only the Jamamandi records have
patta has not been.
not been. Not.
Heard Mr. M. Dr. the learned counsel appearing on behalf of the appellant. This is an appeal under section 100 of the Code of Civil Procedure, challenging the confirmation of the judgment and decree dated 24/2/2022, passed by the learned Munsif number 1, Borpeta, entitled foot number 195/2015, by the dismissal, rejection of the application for condonation of delay by the learned, by the order dated 13/6/2023 by the learned civil judge Borpeta in Mize case number 86/2022. The instant appeal is admitted by formulating the following substantial questions of law. Whether the learned trial court was justified in decreeing the suit in favor of the plaintiff in absence of any document of title being produced before the learned trial, any document of title being produced. Number 2, whether the learned first appellate court had exercised the power under Section 5 of the Limitation Act (1963) in rejecting the application for condonation of delay in terms with the well-ordained principles settled by the Supreme Court. To notice, making it returnable by 4 weeks. Steps be taken by way of registered as well as judicial. Can we fix it on? You don't need to call for a record. Can we fix it on 25th, 24th of June?
Good.
We take steps by way of the state.
Fine.
Then I'll dispose of this thing.
Fine, talking terms, is a may be a problem, but not.
Let him go. So it can be done through an advocate clerk. Now, why I'm saying it, then I can remit it back by condoning the delay of 50 days. Would not consider the first one, then second one I'll do it in then. I think that is the best. Returnable on 24/6. Step by registered as well as in addition to that, the petitioner is the appellants are also directed to take steps by way. Response number 1, 2, and 3.
Yes, but
How did one become more? Kontana Kolita and Ronjit Kolita are the defendants. Okay, they are the appellants. In addition to that, steps be taken by way of the state routed through the registry of this court and file an affidavit of service on or before the next date. It is made clear that the appellant need not take the steps by themselves and the steps by the state by themselves, but can be done through any other person known to them. And however, the said person has to file the affidavit of service.
either I,
This court for the present is not inclined to call for the records. The same shall be considered on the next. What I
first table, there's a
What
direction to cancel the.
let it begin. I did taking into account the judgment and order passed by the learned trial court and relief which have been sought for and granted. The court is not inclined to not press. Mr. M. Dotto, the learned counsel appearing on behalf of the applicant, submits that taking into account that an attempt shall be made to dispose of the appeal on an early date, he is not pressing the input. Yes, Mr.
My lord, trial court has defeated the counter claim. Appeal, my lord, the counter claim has been reversed. That it is the case of
Do you have a good case or bad case?
that I have a
Don't spoil the time, huh?
good case, my
Yeah.
lord.
Then later on,
my
no
lord,
adjournment. Earlier, I have already granted an adjournment. And I give an adjournment means there's something wrong.
no, my lord, because of my some personal difficulty.
Oh, then it.
I'm waiting, but because of urgent leave, my lord.
Okay.
My lord, here, my lord, their claim is that mediation entry made in our favor is wrong. And
Where is your
they claim
substantial
that-
question of law?
substantial question of law I have claimed, my lord, that Lord, you will find in this second page after the screen of six.
Page
Page, my lord, it is in my
80?
my lord, it is in the after the synopsis, my lord. The page after the synopsis, after substantial questions of law. My lord, the learned court below has reversed the counterclaim, holding that there is a doubt of petition.
Okay.
But
What are
whereas
these
the
so
plaintiff
long?
witness have admitted our position.
Huh?
Plaintiff witness have also admitted our case.
Your?
Our case
Then
that Lordship may kindly have.
you
a
had a
look-
counterclaimant.
We have the counterclaim
And the suit was filed for what?
for the right title and cancellation of mediation.
In your favor.
in their favor.
Why will they ask
Cancellation
for
mutation very
cancellation of the mutation in their favor?
make cancellation mutation of our favor.
Okay.
They wants to cancel.
Then right title interest and cancellation of
Right.
mutation. Then
Then my lord,
you file the counter claim,
counter to file the counter claim,
claiming right title
and the
interest.
trial court has allowed our counter claim, and it is the finding
First-
of the court, the court below, that the father of the present appellant is the original patta holder of the land. That is the admission of recorded.
Then how
admission of
did
the-
they get it?
Yes,
The
my
plaintiff, how did they get it?
lord.
How?
My lord, the grandfather of the plaintiff and the father of the defendant, they got the land mutation, and it initially annual patta because jungle clearance land. The jungle was cleared. The government has granted initially annual patta. Subsequently, on settlement operation, after settlement operation,
Well, here at 2
see-
2 o'clock. You are the plaintiff.
I am the defendant. The right to read the but as legal head and task force, it is the defendant for it. Cancel the mutation of the name of Yakub in connection with the case equal land, declaring null and void inoperative with law. Cancel the mutation names of the defendant passed by circuit officer dated 11/8/1999, and the mutation order of circuit officer 13/2014, declare null and void inoperative permanent injunction for except. My lord, in para 8, they have said that the defendant forcefully had entered into peaceful land.
Schedule A land is which is the suit land?
Land is, my lord, peaceful land.
B schedule. So 9 bigas 3, 11 later.
That, my lord, it is their own fee that they were disposed on 2014.
And you have
Whereas,
schedule
my
D
lord,
land.
my lord,
Schedule D land. Schedule A is the schedule land. What? Schedule C is whose land?
Mine.
What is the suit land?
if you see,
Suit land is the schedule A land.
Mine.
21 bigas.
but that
And of which schedule B land is 1. Schedule C land, I think
But
you have
counterclaim is only in respect of 10 bigas 3 kata 12 rasta in schedule A land.
schedule.
A land, not the whole, my lord. They claim counterclaims, my lord. 10 bigas 3 kata 12 rasta. They also sought partition of the state land.
So schedule B and C are part of
Mine.
schedule A land,
A land.
and schedule D land is a part of schedule C land. So they are asking for confirmation of possession
My lord.
and for cast
they are also
possession.
asking for eviction because they claim that they were disposed on
From schedule D land.
schedule D land.
Now, what is your stand?
Our stand is, my lord, it is our father was the original patta holder, my lord. Initially, government has granted annual patta jointly to the petitioner's father and grandfathers of the plaintiff. Jointly, annual patta was given. Subsequently, my lord, after settlement operation in 1958-65, then thereafter, my lord, it was converted into patta land.
In whose favor?
My lord, jointly, my lord, the father of the defendant and the grandfather of the plaintiff.
They were having the periodic patta.
Yes, my lord. My lord, it is based on the CITA. There was a CITA prepared during settlement operation 1950-65. Based on the CITA, there was annual patta. But while making my lot substation revenue record, there is one mistake, and that has based on that mistake they are claiming everything. And the both the courts below has recorded finding that for the evidence that the father of the defendants were the original one of the original patta holder. So team may kindly have a look at the judgment of the trial court as well as the appellate court. The evidence has been recorded.
So you ask for 10 bighas of land
Yes,
for
half of the
half of it
Receiving land.
and also for khas possession of 4 bighas.
Right.
Then
My lord,
What happened in the
kindly
trial
have a look at my lord paragraph 20 of the trial court judgment, page 25.
trial court judgment is there.
My lord, it's, my lord, start from
Yes.
page
8.
8. My lord. Start from page 8. But you may kindly turn to page 25, paragraph 20.
Now, whether the patta was at all exhibited? Patta was exhibited.
My lord, executed, my lord.
Patta was
Yes,
exhibited.
my lord.
Whose name were there
My lord, my father's name is also there.
in the patta?
Yes, my lord.
So,
That is admitted, my lord. Paragraph 25 of the trial court judgment, page 25. During cross-examination, Lordship got it.
numbers B and C, 2 and 3. 2, 3, 4. Well, How did the defendant prove their counterclaim?
My lord. There, the draft chitta,
Drapsita, on
Draft-
one hand, he has produced the Jamabandi.
my lord.
Jamabandi is not good, but Drapsita is good.
My lord. Is Jawandi also, my father's name is there? my
No,
lord?
no, the trial court rejected the plaintiff's case on the ground that the patta was not exhibited. Whereas allowed your case on the basis of a draft.
My lord.
Sita.
Subsequently, there was a, my lord, Jawandi also. That correction
What are
also-
these are records of these are record of rights.
Lord,
Record of rights does not confer any title.
my
These
lord,
cannot be taken as title
my
document.
lord, annual patta
Then
given
how
by the
did
government.
how your what do you call without the patta or any order
My lord.
of the deputy commissioner showing that you have been granted the patta in respect to whoever has been granted the patta, because oral evidence can only be at best said to be some secondary form of evidence which can be given
My lord, in paragraph 48, my lord, goes to show that
unless the document is not
the
disputed.
draft chitta was exhibited. Draft chitta was exhibited, my lord.
Draft cheetah has
Then
no value.
Jawandi, my lord.
See, what is the stage of a draft cheetah? The draft cheetah comes, after the draft cheetah comes the cheetah. Then in the meantime, everything happens, then you have the Jamabandi. Jamabandi is called the record of rights
Yes.
as per Rule 41. So under such circumstances, when the Jamabandi has been disbelieved for the case of the plaintiff, how a draft cheetah is being taken for the case of a defendant?
My lord, in Jawandi, our name is also there.
Very well. But how did they hear the court come to a finding that you are entitled to 10 bighas?
Because my father's name is also there, my lord, in Jawandi. In draft chitta also.
So both of you could not have proved it. If we apply the same yardstick,
Right.
which was applied by the trial court for the plaintiff, the same should have been applied for the defendant.
My lord, fact is, my lord, government has granted annual patta.
That annual patta is not before the court.
That was not.
Then what are they exhibited? Plaintiff exhibited the certified copy of the Jamabandi. Exhibit 2 is the original certified copy of the Jamabandi. Defendant's exhibit is certified copy of the Jamabandi. Then exhibit certificate of the draft sheeta, certified copy of the draft sheeta, draft copy of the sheeta. Sheeta is there. Sheeta, after the sheeta comes the Jamabandi. Jamabandi has a much better value.
My lord,
Then
government is there, my lord. Our name is also there.
maybe, but for that, how can you prove it on the basis of Jamabandi? You are not entitled to the record of, unless you produce the document on which either you produce the patta is not there, or you have to produce the whatever that document it is, the document by which it was converted, and there is some order passed by the government. Nothing is there. So how
My
could
lord,
this
we are on the land, my lord.
would have been
My
decreed,
forefather, my lord.
the
Their
dismissed?
claim is that we are to disposes them, but no issue on the possession and dispossession was framed. And it is their own admission that we are in the land, my lord, since my forefather. But they claim that they have been dispossessed by us. But no
Whereas
issue was
issue
framed on
number
that.
3 is wholesome to take note of whether the plaintiff has right for class possession over the Schedule D land. That will include the question of dispossession.
Right.
Then what happened? How many appeals were filed?
My lord, appellant,
One appeal.
One.
And this appeal was what happened?
the appeal has been, my lord, our counter claim has been set aside.
Rightly.
Right.
Rightly. That is what the appellate court held. Right or not?
My lord,
How can you get a counterclaim? The right of a counterclaim unless that patta is not there. First appellate court judgment is good, right? They have applied the same yardstick. If you are to get here, why not the plaintiff get the same thing? We don't have a good case.
my lord, we are in the land, my lord, is pre-independence period. Pre-independence period.
Understood. You have a pre-independence period, but you have not proved, either of you.
My lord,
Either of you have not proved it.
my lord,
So rightly, the court dismissed the suit. The court dismissed the counterclaim. Rightly.
my lord, the appellate court has hold a view that the mutation entry in favor of my father, that is doubt.
Fully, whether it is a different thing,
That
I'm
we
not
have
on that.
challenged, my lord.
That
yes.
is nothing to do. That is not a substantial question of law. The question out here is you have also failed, he has also failed, nothing is there. You have, both of you did not produce any document of title. That ends there. Chalo. What to do? That is why I asked you before taking up the matter, are you serious? Now the time has been spent, so it is a case for dismissal.
My lord, let me have a start
For what? Withdraw.
for door.
How much?
My lord,
New case, you have the phone number
my lord,
next Monday.
time phone number also not working. At least 10 days time.
Next Monday. Phone number does not work, does not arrive. Recently, you have got this case. You have filed this case recently. Then it's a 2024 second appeal is there. Then now also you are saying the phone number does not work, cannot happen.
That is 10 days time.
Mr. A.R. Sikdar, the learned counsel appearing on behalf of the appellant, seeks for an accommodation to obtain instruction as to whether to proceed with the appeal or not. Taking into account the above, list the matter again on 25/2000. Get your instructions. Yes, what is this?
This, my lord, responded, the plaintiff filed a suit and the suit was dismissed. As against that suit, they filed an appeal. In appeal, my lord, partly allowed the appeal. But fact is that, my lord,
Who are you, the defendant?
Defendant.
Then
then, my lord, actually in the appeal, we are not receiving any notice.
Huh?
And we are not appeared also, but someone appeared. And I also come to learn about the fact that when the execution proceeding is started, then I will receive.
where is the appeal? এখন তো এবার পরিবারই বলছেন এত বিচারিয়ে না পাই এই যে appeal memo তো মাফ করব yes I think the judgment of the yes tell me
When, my lord, the plaintiff did not challenge the sale deed. We stated that we purchased our father purchased the land by various sale deeds. Those these were exhibited, and those deeds were not challenged. The planet trial court has held that they have made objection that those deeds were not proved in accordance with law because all the writers were experts, 30 years old deeds. So court accepted it.
suit was dismissed by the trial court
By better.
You are the defendant.
Okay.
Okay, then
Then they file appeal.
they filed appeal.
Yeah.
What happened in appeal?
In appeal, my lord, they only held that the or the one person, the father of the petitioner number one, full one, passes the land. That deed was not executed.
Huh?
In the appeal,
Hmm.
it says you will also file this page 33, the appeal, memo of appeal. And the finding mail. Finding is page 43.
So patta number 25, you had no
No,
dispute.
I am no.
So that was the declaration given.
Right.
So there is okay.
With
Now,
only
did the
20
plaintiff ask for that patta?
My lord,
Did the plaintiff I had asked for that patta?
Yes.
What is the plaintiff suit for?
page 51 is the place.
The total land in patta number 25 is only 2
So
bighas.
2 bighas something.
You have
And
no problem, but
yes,
it is
eight
only as
big-
regards 8 bighas.
8 bighas. 8 bighas, 2 cutters, 5 plus. It is mentioned in the schedule, my lord, page 53. But in the plan, they did not mention which portion of land, how many, who will occupy how much land. There is no partition also.
So exhibit D, E, and F you did not produce.
all the documents put, you also can see all documents are put, page, my lord, 18 of the judgment file put judgment.
Page?
Page 18, my. The title one exhibited the following document. A, B, C, D, E, F, G, H.
What does it say? Paragraph 43, page 43?
Yes, page 43, they mentioned that in
As per
respect
the
of one
involvement of the
megawatt of land
defendant in the
purchased by
written
Jamshedpur
statement,
is not been put.
the
It is
Wahid
actually
Ali
different.
allegedly again sold 1 bigha of land in the year 1965 to Jasmuddin, and the same Jasmuddin in the year 1975 executed 3 deeds of sale. Who is Wahid Ali?
What is the plaintiff? He himself said,
He sold 1 bigha in the year, and that 1 bigha of land was sold by 3 numbers of sale deed, exhibit D, for a land measuring 3 kata 10 lecture in favor of Umid Ali. Umid Ali is the defendant. 1K in favor of Sahiman, the grandmother of the defendant, and again sold 1 kata of earth to the aforesaid deed. But materials available in record disclose that no sale deed has been produced by the defendant, to which Jasmuddin allegedly purchased the land measuring 1 bigha in the year 1965 from Wahid Ali on the strength of it. So, under the
page
document
17,
like
paragraph
went
6
to
is the
create
law.
it,
It is mentioned.
on the
The
strength
paragraph
of
6.
these alleged-
Paragraph 17, page 17, paragraph 6.
What?
It is mentioned.
Understood whether that document was at all
yes.
produced.
Why, yes, one
How
Jasmuddin
do I know?
had purchased 1 bigha of land on the opposite plot of from one Wahid Ali, Sanjay Sensu. White held it number 36972. Again, Jasmuddin purchased 1 bigha of land.
No, for you, there is one person, Zakir Hussain, who appeared. Why didn't you produce it?
Zakir Hussain.
Some lawyer appeared.
That is the fact, my lord. I got the order copy also. I obtained all the order copy. So that's why I obtained all the order copy. The appeal copy.
What does he say?
Only say defendant appear. 2 or 3 days, appeal has been dismissed to the matter. Only within 2 or 3 days, 4 or 5 days, I think, appeal has been dead.
So, what is wrong?
But in fact, we are not receiving any notice. We are not receiving,
You were not?
not receiving any notice from the appellate court. Even we are not appearing with the appellate court. When the execution proceeding is going on, then we receive a notice. Then we in court matter come to learn that appeal was decided in our absence.
So, there was a delay here.
Yes, delay has been conducted. Illustratively conducted delay last petition. Illustratively, IA number 836. I number 836. I also include the execution case. That execution case. And this novel court also state that we asked our client time and again. They said, no, we are not never repair, we are never engaged any lawyer in appellate court.
On many occasions, somebody appeared.
Just as some private performer defendant in collaboration with them may appear or may someone accept notice.
Then why didn't you apply under order 41 rule 21 there?
Because there is a delay, that is why
The delay here also is there.
that's concern.
Different thing, but why didn't you apply there? Because your main concern with the document D, E, and F as to whether such document is there on record. Your only substantial question of law is as to whether the document, the exhibit D, E, and F is a part of the records or not.
But it is only in this 1 week, land of 1 week. 1 week. But other land is there. That is not disputed.
Then other land he has not stated anything.
Well, consider trial to judgment, it fair judgment. Paragraph 16 is clearly stated and paragraph 23 clearly discussed about evidence on record.
The
The learned evidence court did not even consult evidence, my lord. The first evidence court is the
Learned
fact,
appellate
my lord.
court have duly done it, but anyway. Heard Mr. J. Ahmed, the learned counsel appearing on behalf of the appellant. Appellant or appellant?
Appellant.
This is an appeal filed under section 100 of the Code of Civil Procedure challenging the judgment dated
To the 9/5/2003.
dated 29/5/2018,
7/6/2003.
passed in title appeal number 25 of 2017, whereby the said appeal was partly allowed by interfering with the judgment in plea dated 30/5/2017, passed by the learned Munsif number 2, Nagaon, Assam, entitled suit number 140/2008. The instant appeal is admitted by formulating the following substantial questions of law. Whether the learned trial court, first appellate court, whether the judgment of the learned first appellate court suffers from perversity in not considering the exhibit D, E, and F. D, E, and F. Exhibit D, E, and F. Though the same was very much available in the records. Number 2, whether the learned first appellate court was justified in decreeing the suit for recovery of possession without there being specific boundaries mentioned in the plaint, wherefrom the plaintiff have been dispossessed. I think these two is enough.
Another,
No, enough. You have got 2. One is a bonus.
their appellate court did not discuss the evidence while passing the evidence point. Did not give the reason.
Mr. J. Ahmed, there is a difference between a grounds of appeal and a substantial question of law. Yesterday, do you know, because of one substantial question of law extra formulated, the appellant not only suffered the appeal, dismissal of the appeal, but it went completely against he had some right. That also went because of that substantial question of issue notice making it returnable by 6 weeks. Call for the LCR. Steps be taken by way of registered
Well, there is the IA.
for stay.
No, actually, I was filed a petition Because since there is a delay, I will file a petition under section 151 for staying the execution proceeding. That was stay.
Then what happened?
That's so the still dispute of the appeal.
Now what do you want?
2009.
Kunki, I can't arrest you, Kunki.
Gate 36.
This one,
Yeah.
this is one. I 86 of the 2019. The delay was condoned how? There was somebody who appeared, nobody.
They appear.
Then where are they? Who appeared?
Panchali, Panchali,
Huh?
Panchali, but
He was appeared. This is an application under section 151 of the Code of Civil Procedure for stay of the title execution case number 22 of the 2018, pending in the court of the Munship number 1 Nogam for this court by an order dated 6/3/2019 had stayed the said execution case till disposal of the condonation application which was filed. Taking into account that there is a specific provision under which an application is required to be filed under Order 41 Rule 5 of the Code of Civil Procedure. This court is not further extending the state order, which already stood vacated, which already was not enforced in view of the condonation of the delay in view of the disposal of IAC 791 of the 2019 on, when was it that disposed? On 29/4/2024. The instant application stands closed, which, however, liberty is given to the applicant to file appropriate application under Order 41 Rule 5 if so advised. The raise this court have also taken this court had also taken note of that notice was issued that during the in the proceedings of the instant case for condoning the delay, the respondents have duly participated to their lawyer by filing a wakalatnama on because I think we need to change this aspect. Cannot be that condonation one thing anyhow. Because of surveys, the matters have been pending unnecessarily for years. Filing a wakalatnama on 22nd of November 2019. The said wakalatnama so filed on the basis thereof, there are only 5 respondents
5 respondents and performance already
struck off.
they are not appeared.
They are struck off or not?
Struck off. Struck off.
Is there an order of
It-
striking
it-
off? It is issue notice no kori.
I will have copy to the Panchali.
issue notice to no koribo ha ei last likhi na issue notice dokar nai. This court have duly taken note of that in the proceeding and for condonation of delay, the respondent numbers 1 to 5 had duly participated in the said proceedings. Under such circumstances, this court is not inclined to issue fresh notice upon the said respondent number 1 to 5. The learned counsel for the appellant is directed to the learned counsel for the appellant is directed to serve extra copies of the memo of appeal upon the counsel who represented the respondent numbers 1 to 5 in the condonation application. The registry shall show their names in the said in the causes. Yes, what is it?
Please, Lordship, whatever this plaintiff PW1, your Lordship, he was cross-examined on number of pockets by the defendant. And in the written statement as well as the other correspondence also, your Lordship, we have found that here for the defendant, your Lordship, and the plaintiff, my learned friend represent, there are some criminal backgrounds, your Lordship, about the plaintiff is concerned.
You are a plaintiff?
I am defendant.
He's the plaintiff.
He is plaintiff.
What did you want? What application did you
Now,
file?
the will come to section 132 of the evidence. Act.
Yes.
Section 132 of the evidence act I am reading.
It is
A witness shall not be excused from answering any question as to any matter relevant to the matter in issue in any suit or in any civil or criminal proceeding upon the ground that the answers to such question will criminate or may tend directly or indirectly to criminate such witness, or that it will expose or tend directly or indirectly to expose such witness to a penalty or forfeiture of any kind. Provided that no such answer which a witness shall be compelled to give shall subject him to any arrest or prosecution or be proved against him in any criminal proceeding, except a prosecution for giving false evidence by such. Now, during the course of cross-examination, your Lordship, some questions on his reputation, veracity of his statement, your Lordship, he has made, and other things, based on some affairs and other things, your Lordship, wanted to be by the defense. When it was put, your Lordship, he straightway, your Lordship, answered that I am not going to answer this question. Because he is the plaintiff number 1, but he has been cross-examination, your Lordship, after all the other witnesses were cross-examination, because he was in jail. He committed fraud to the excise department to the tune of rupees 19.85 crores. That is the basis. The Lordship will find in our petition, that is this Rajesh Kumar Jalan, your Lordship, is a known figure over the field of fraud is concerned.
He's a known figure.
Known
Yeah.
figure, your
If
Lordship.
he's a known figure, why should I take it?
Lordship.
I think I
Lordship,
should recuse myself if it is known to me also. Let it come up before any other bench.
that field, your Lordship.
No, let it come up before any other bench.
Yeah.
Let it be done by somebody.
No, your Lordship.
Isn't it?
Your
Better
Lordship.
off if he is a known
Your
figure.
Lordship, he was during that period, your Lordship, he was in custody. That's why, your Lordship, he couldn't be examined, your Lordship, cross-examined part. So all other witnesses, that is 5 other witnesses, they were examined. cross-examined your lordship. He was, lastly, he was cross-examined when he was out from the jail, your lordship. Now, in this method, your lordship, the defense wanted to put some questions on his criminal background. And that your lordship will come to page 146, section 146.
What is your suit for?
Your lordship,
You are the defendant.
I am defendant. I wanted to put some questions. Your
Which,
lordship.
what is the suit for?
Specific performance contract.
And how is it relevant?
Your lordship,
How is it relevant, these questions?
suit for declaration of right title and test, your lordship.
No, this is for specific performance, he's saying.
Suit for specific performance of contract, your lordship.
Yeah.
Our suit is, your lordship.
You also filed the suit.
Your contract claim, your lordship.
Counter
Contract
claim for
claim is
what?
there, your lordship. And in the contract claim, we have stated that some declaration should be made. Whatever addendum he has added to the main agreement, your lordship, that is the fraud. He has manufactured it, and I never actually placed it before any authority for either before the.
Where is your
notary
counterclaim?
or sub-register, lordship.
Counterclaim is where? Where is your counterclaim?
Your lordship, contract claim along with the written statement, your lordship. Your lordship,
How is it relevant, these questions?
relevant, your lordship, because
It's a case 52, my lord. Contract.
How is it relevant? Whether he is in jail or not?
at page your lordship will find. So for 57, is where is concerned, your lordship, 56, relevant page is 56.
Now, how is this relevant as regards?
Relevant, your lordship, he committed, your lordship, he committed fraud.
Upon
With the state government, he committed fraud with us also, yes, with us also, because he has.
No, he has
manifested
committed fraud with you. You ask whatever question you want.
lordship.
But the fraud against the government, how is it relevant?
How it will, that means, your lordship, fraud is actually his habit, committing fraud.
What?
It is habit, your lordship.
No, no, no.
Because your lordship will find, we have annexed some documents, there is a FIR as well as other things. It has been registered by the CBI. And CBI registered case against him, your lordship, and your lordship will find. I am coming to the page, your lordship, that is fraud, your lordship, that is page 42. Page 42, your lordship.
So you see, Mr. Ali, neither this is a case of fact-in issue or relevant fact or anything introducing those relevant facts.
Lordship, during the pendency of this suit, before that also, your lordship, he committed with other organizations.
Whatever may be, this is not a question which is relevant.
No, your lordship, this act says, your lordship, this evidence act, your lordship, he can be questioned.
You can be questioned, but the court may not allow you to.
No, when he can be questioned, now your lordship
Court
comes
may
to the.
not ask you because the
lordship,
question
comes
is of.
to the- comes to
No,
the
no, because of cross-examination, you can all ask all these things.
146, your lordship. 146.
Where about
your
146? Keep, yeah.
146, your lordship will find.
No, why we will go to 146? 146 is too far away. Let us come nearby.
32.
Section 5.
132, your lordship,
Section 5.
section 5.
Yeah.
Evidence may be given of facts in issue and relevant facts, your lordship. Evidence may be given in any suit or proceedings of the existence or non-existence of every fact in issue and of such. Your lordship, this is giving of evidence, not cross-examination, your lordship.
What is cross-examination?
is something else.
No, cross-examination is also a part of evidence.
Your lordship, then come to 146, your lordship.
146 is will go.
146,
You
your lordship.
cannot put certain questions
No,
which
no,
are not
just-
necessary.
Just 1 minute, your lordship.
Let it be tested by the Supreme Court.
Lordship,
Chalo.
Lordship, 146.
No, nothing.
Let me place your Lordship.
No, nothing. Enough. These matters doesn't require much time.
Because I have already in the written statement, your Lordship, I have taken the plea that he is involved in such and such case. Those are also case on.
Those being having any fraud out there, anything he has done
Then
out there
what
has
is the
no
use of
relevance
this
out here.
question, your Lordship? Then what is the use of
those
this
are only allegations,
150?
my lord.
Yes,
Raju,
you may put it, which has relevant or which has relevant,
relevant,
which is
your
a
Lordship.
relevant fact or a
He
fact in
committed
issue
fraud with
or
us also.
relating to introduction of a fact in issue.
Lordship,
No.
he committed fraud with us also, your Lordship. He
Yes.
committed fraud with his
Whatever may
state.
be, they have
he
committed a lot of
committed
fraud
with the
against
others.
you.
That
Understood?
means, your Lordship, at least your Lordship, 146, your Lordship.
146 has to be read in
146,
that
your
context.
Lordship. Questions lawful in cross-examination. When a witness is cross-examination, he may, in addition to the
Come
questions,
to 8, against section 8. We are not going to 46. 146 has to be read on the basis of relevancy.
Lordship, let me
No,
complete, your
nothing
Lordship.
doing.
Let me complete, your Lordship.
No. Okay. Let me write
Now-
it down.
Now, let me complete, your
No,
Lordship.
nothing doing, Mr. Ali.
So, Section 8 says something
This
else.
is an
here.
application under Article
Section
7 of the
Motive,
Constitution.
preparation, and
No,
previous and
nothing
subsequent
doing,
conduct.
nothing. This is an application under Article 7 of the Constitution challenging the order dated 14/6/2023 passed by the learned court of the Civil Judge number 2, Kamrup Metro at Guwahati, in connection with petition number 2967 of the 2022 filed by the petitioner herein, who was the defendant in the suit, under section 151 of the Code of Civil Procedure. This court have duly perused the application filed under section 151, wherein it has been mentioned that on 14/7/2022, when the plaintiff witness number 1 was put to cross-examination, certain questions were put in respect to these two TS case number 1633/2014 under section 467/420/423 of the Indian Penal Code, and case number 54/2015 registered by CID under section 120B/468/471/409 Indian Penal Code, and his arrest on 5/12/2016 and in the year 2018, and regarding raids in his office on 29/3/2019, which the plaintiff witness number 1 refused to answer. It is under such circumstances the said application was filed, seeking a direction from the court to direct the PW1 to answer those questions as stated in paragraph number 1 of the said application. The learned trial court, by the order dated 14/6/2023, rejected the said application, stating that the questions which have been, the said aspect which have been mentioned in paragraph number 1 of the said application are filed under section 21/151 was not found relevant to the subject matter of the present suit, and as such, as the same is not a matter in issue in the said instant suit. It is being agreed the petitioner has the defendant, who is the petitioner, has approached this court. I've heard Mr. S. Ali, the learned counsel, appearing on behalf of the petitioner, who has drawn the attention of this court to section 132 as well as section 146
and 147.
and 147 of the provisions of the Indian Evidence Act 1872, and submitted that, taking into account the taking into account that in the instant case, the proviso to section 132 would not be applicable, the PW1 would therefore, the PW1 therefore ought to have been directed by the learned trial court to answer to the said question, which were put. This court have duly taken note of the suit which was filed by the plaintiff, which was a suit filed in the year 2014, seeking specific performance of the agreement for sale of land dated 28/8/2009 and the addendum to the agreement for sale of the land dated 30/4/2010. In addition to that, the plaintiff sought for realization of compensation the defendant, on the other hand, filed a counterclaim, filed a counterclaim. On 18th of February 2015, seeking a realization of a sum of rupees 40 lakhs along with interest at a rate of 20% per annum against the plaintiff, as well as for a decree declaring the rescission of the agreement of the contract dated 28/8/2009, as well as the addendum dated 30/4/2010. It is also seen that the cause of action, as stated in the said counterclaim, is in paragraph number Roman 9 are dated 28/8/2009, 30/4/2010, and 12/10/2011. This court further finds it very relevant to take note of Section 8 of the Indian Evidence Act 1872. Which stipulates as to when a motive, preparation, and previous or subsequent conduct becomes relevant to the A perusal of the said section reveals transpired that any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. In addition to that, it has been mentioned that the conduct of any party or any agent to any party to any suit or proceedings in reference to such suit or proceeding or in reference to any fact in issue therein or that relevant thereto, and the conduct of any person and an offense against whom is the subject matter of any proceeding is relevant if such conduct influences or is influenced by any fact in issue or relevant fact, whether it was previous or subsequent thereto. Stop. In the instant case, there is nothing to show that the cases, more particularly the dispute PS case number 1633/2014, registered under section 467, 420, 423 of the Indian Penal Code, and case number 54/2015, registered by the CID under section 120B oblique 468, 471, 406 IPC, and the arrest of the PW1 on 5/12/2016 and in the year 2018, and the raids which were conducted in his office on 29/3/2019 have any relevance to the fact in issue or the relevant facts? The fact in issue or the relevant facts as stated in paragraph number in section 3 of the Indian Evidence Act 1872, read with of the facts in issue as well as the relevant facts in the suit as well as in the counterclaim. Considering the above, this court finds no ground for interfering with the order dated 14/6/2023. Accordingly, the instant petition therefore stands dismissed with cost quantified at rupees 10,000. Dismissed. The interim order dated 4/8/2023 stands vacated, and the parties are directed to appear before the learned trial court on 3rd of June 2024 for further proceedings of the suit. And the basis of your title is not your title, your right to remain in possession is because of your father, who was a tenant. And now later on, he says that 20 years he has not put. He may not ask for rent.
Yes.
That doesn't give. It is not your case of limitation.
I will not argue that overall because
So we dismiss this.
it is only 200 square feet. He has constructed, he has done last so many years. Now 2018, they have come up and took this big. There is no anything. I will not pass over. Nothing to say about it.
This is an application under section 115 of the Code of Civil Procedure 1908, challenging the judgment and decree dated 8/11/2023, passed in title appeal number 17/2021, whereby the judgment and decree passed by the learned trial court, that is the court of the learned Munsif Toraido, in title suit dated 30/4/2021, in title suit number 10/2018, was affirmed. The case of the respondent herein, the facts involved, the issue which is to be adjudicated herein as to whether the judgment and decree passed by the learned First Appellate Court suffers from any jurisdictional error, or the exercise of the jurisdiction has been done illegally or with material irregularity. For deciding the said aspect of the matter, the question which requires that this court finds it relevant to take note of the brief facts involved in the instant appeal, instant proceeding, and the brief facts leading to the filing of the instant proceedings. The respondent, you are a respondent?
Yes.
The respondents as plaintiffs had instituted a suit being title suit number 10/2018 before the court of the Munsif at Soraido, seeking ejectment as well as realization, seeking ejectment of the defendant from the tenanted room as specifically described in the plaint, as well as for realization of area rent. It is the specific case of the plaintiff in the suit that they are the owners of the shop house which have been specifically described in the schedule to the plaint and was originally truth house is the case of the plaintiff that the plaintiffs are the owners of the shop house as specifically described in the schedule to the plaintiff. The said shop originally belonged to the father of the plaintiff, who died on 7/9/2015. And after the death of the father, the plaintiffs got mutation of the land as out upon which the shop house stands. It was further mentioned that during the lifetime of the father of the plaintiff, a monthly lease was created in favor of the defendant of rupees 800, terminable within 31st of each succeeding year. And according the lease term expired on 31/3/2018. However, on 1/4/2018, when the plaintiffs requested the defendant to vacate the suit premises, the defendant did not vacate the suit premises. And on the other hand, also did not pay the rent till the month of did not pay rent since July 2018. It is under such circumstances the suit was filed in the month of December 2018. The defendant filed a written statement along with a counterclaim. Stating entirely at paragraph number 9 that the defendant took the suit room from the plaintiff's father from 1st of February 1986 to 31st of January 2000 on a monthly rent of rupees 100. After the expiry of the lease term, that is on 31/2/2000. What is this 31/2/2000? How can there be 31/2? 31 after the expiry of the lease term, the father of the plaintiff allowed the defendant to remain in the suit room with an assurance to renew the lease agreement with the same rent and conditions. But the plaintiff's father asked the plaintiff father asked the defendant to vacate the suit room. The defendant refused to vacate the suit room. And thereupon, also refused to vacate the suit room. And thereafter, continued to remain in possession of the suit room without any relationship of landlord and tenant, peacefully, without any hindrance. From a perusal of the said written statement, it therefore transpires that the defendant duly admits that his father was a tenant of the father of the plaintiff, and thereupon, after the period of lease, which was up till 31st of January 2000, was over, the defendant claims, denies the title of the landlord. It is on the basis of which the defendant claimed adverse possession, claimed acquisition of adverse possession over the suit room on the basis of acquisition of rights over the suit room on the basis of adverse possession by way of the counterclaim. On the basis of the said pleadings, the learned trial court framed as many as 5 issues, of which issue number 3 was as to whether the defendant is a tenant of the plaintiff of the suit room and whether he had defaulted in payment of the rent to the plaintiff and as such liable to be evicted. The learned trial court on the basis of the pleadings as well as the materials on record, as well as the evidence, had come to a finding that the plaintiff, the defendant, was a tenant of the plaintiff, and as such, he was bound to pay the rent in order to be protected in terms which from Section 5(1)(e) of the Assam Urban Area Rent Control Act 1972. However, as the defendant have admittedly not paid the rent, he was a defaulter, for which the issue number 3 was decided in favor of the plaintiff. As regards the issue number 6, which was an issue pertaining to adverse possession, the learned trial court held against the defendant, holding that there was the case of adverse possession was not made out. In the opinion of this court, the state trial court have rightly done so, inasmuch as a tenant is always a tenant, cannot claim adverse possession is a well-settled principle of law. On the basis of the above, the learned trial court decreed the suit in favor of the plaintiffs, thereby granting 90 days to vacate the suit premises and also to pay the area rent from July 2018 till he hands over the vacant possession of the suit land, suit house, suit property. Against that, an appeal was prepared by the defendant, which was registered and numbered as title appeal number 17/2017. The learned first appellate court, after taking into account the provisions of Order 41, Rule 31 of the Code, decided the said appeal, dismissed the said appeal by confirming the judgment, the decree passed by the learned trial court. Against that, the present revision application has been filed. I perused the impugned judgments passed by the learned first appellate court as well as the judgment of the learned trial court. This court have also perused the judgment of the pleadings of both the parties, wherein it is an admitted case of the defendant. The defendant's father was in possession of the suit premises, was a tenant, and the defendant claims the right to be in possession of the suit house on the basis of his father having taken possession, being in possession as a tenant. Under such circumstances, the defendant being a tenant, the defendant cannot claim adverse possession against the plaintiff. It is also very relevant to take note of that that admittedly, even on the basis of the pleadings of the defendant, it is clear that the defendant have not paid the rent since 2000. And as such, being a tenant, he is a defaulter, for which the learned trial court as well the first appellate court were justified in declaring the suit. Consequently, this court therefore finds no jurisdictional error committed by the learned first appellate court in passing the judgment and decree passed dated so and so. Decree dated 17th of 8th of November 2023, entitled Appeal number 17/2021, for which the instant petition stands dismissed with cost. New case. It cost. You appear.
The direction may kindly be given to comply the order of learned trial court
Oh,
within the
no.
timetable.
You have to file execution with cost of rupees 11,000 quantified for the instant proceeding. In addition to that, the plaintiff shall be entitled to cost throughout the proceedings. In name order, if any.
Item 16 for order.
Also, I'm appearing on behalf of respondent of three lawsuits. Appeal has already been abated lawsuit against respondent one.
None appears on behalf of the appellant on call. Mr. Mboro
Yes, Lord.
appears on behalf of the respondent. This court had, by an order dated 3/5/2024, had also noticed that the appellant was not represented. Accordingly, taking into account that the appellant is not represented, the instant proceeding stands dismissed for non-prosecution.
Deeply obliged.
Dismissed for default. The appeal stands dismissed for default. Has the LCR come?
Yes, Lord. Yes, yes.
The LCR, the registry shall return the LCR after 3 months from the date of the instant. None appears on behalf of the applicant on call. This is an application for condoning the delay of 272 days in filing the revision application against the judgment and decree dated 15/12/2011 in title appeal number 13. 13 of the 2010, whereby the judgment and decree dated 22/11/2010 passed in title suit number 19 of the 2001 by the learned Munship number 1 Morigao was upheld. This court had duly taken note of that on the earlier occasion the appellant was duly represented. However, the counsel appearing on behalf of the applicant have filed an affidavit on 18/11/2022 intimating, it's showing inter alia that the petitioner here in the applicant herein have been duly intimated about their withdrawal. It is under such circumstances on 10/3/2023, this court made a clear observation that the name of the counsel for the applicant are struck off, who were earlier representing the applicant, and the applicant was directed to take appropriate steps for making alternative arrangements. In spite of a passage of more than 1 year, no steps have been taken. Under such circumstances, it seems that the applicant is no longer interested in the instant proceedings, for which the instant application stands dismissed for non-prosecution. The consequential effect of the instant application being dismissed is that the accompanying revision application so filed cannot be entertained, being barred by limitation. Yes, we are not taking steps.
My lord, we have got duty engaged in the month of March.
You were engaged in the case. 3 months have gone by.
My lord,
Earlier, Mr. B.K. Sen, counsel representing, has said that he is newly engaged. Now, after 3 months, you are no longer new. Now you are old.
My lord, 3 days time to be allowed.
Mr. B.K. Sen, the learned counsel appearing on behalf of the appellant. What is this?
My lord,
Revision for what?
my lord,
Landlord tenant?
Yes.
Okay, we can dismiss this. What is this revision? It's a second appeal.
my lord, first, second, thereafter it was converted by the order of this honorable court.
Okay. What is your ground?
Yes,
You are a tenant.
I am, my lord, landlord.
Oh.
To decree, my lord, the first appellate court, my lord, reversed the decree, saying that, my lord, the owner of the land, admittedly, the owner of the land is municipal. If you got,
Then why you are not taking steps?
but I said, it is.
Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner, submits that he would take steps within 3 days upon the respondent number 2, 3, 4, and 6, who's taking into account the above, list the matter on 1st of August 2020, 2nd of August 2024. In the meantime, by 22nd of May 2024, steps be taken against the respondent number 2, 3.
4 and 6.
Who are you?
I am respondent of 5 and 7.
Who is that?
Count 4 and 3.
5 and
And
7. You are all brothers.
Yes, in this case already the DK Das engaged the counsel. He is now admitted in polyclinic hospital.
Where?
DK Das, the engaged counsel, appeared in this case. Now he is admitted in polyclinic hospital due to his illness. So today he is unable to appear before.
It's okay. I'm not on that. I'm not going to dispute. Why you are not appearing for others?
Yes.
You appear for others.
No, as per instruction by senior, he is appearing on the respondent of 5 and 7.
No. Why you are not appearing for the other brothers? This is a suit for what? Recover the tenant. Who is the original tenant? Nipendra Chandrapal.
Yes.
So as per the judgments of the Supreme Court, it is not required to make all the heirs a party.
Right.
So we can proceed against 2 and finish it off. You appear for the others. Okay, to Karok. Mr.
RK.
RK? Nath. It submits that he has filed a wakalat number to appear on behalf of the respondent number 5 and 7 He further submits that in taking into account that the other respondents are also the successor in interest of late Nipender Chandra Paul, who was the original lessee. He would file the wakalatnama on behalf of the said respondents on the next date. List the matter again on records have come. It's the record. List the matter again on 1st of August 2024. The wakalatnama be filed on within 15 days from today on behalf of the other respondents.
I love.
It's the matter for hearing
Yes.
on 1st of August is a
Fine.
Friday, Thursday. Okay?
Right.
Finish it off.
Okay.
In this matter, we have taken step, Your Lordship.
When?
Your Lordship, already taken. And taken
Mr. Sri Sharma, the learned counsel appearing on behalf of the petitioner, applicant, submits that he has already taken steps today.
on response number 4. Lord. With regard to response number 3, the case is evident. Not contact, so we can file the
Yes, why should we restore it?
but the earlier council.
The restoration, no, you can't have like
No,
this.
no, Lordship,
You are not good. This is again landlord tenant. 227. The main case.
but the earlier council.
Unnecessary,
expired, Lord.
not necessary. What is this type of matters? 227 matters, what you are challenging? No, happened 2012 matter, you can't go on. What are you challenging? Unknown. Order dated demand passed in demand by way to set aside the order dated demand, closing the evidence of the petitioner and demand and fixing the suit for evidence. What has happened in the meantime about the suit?
I don't have it.
Hey, Hunoktun. A to अपनी section title suit number 15/93 मुंसिफ नॉर्थ सालमारा भाई itu section की अवस्था you don't go 15/1993 what happened so this suit has already been disposed of what remains we can restore it to Ra. We take it after some taking unnecessary steps doesn't make it to you'll find it out there in eco. You don't go, Mr. Sri Sharma. You just find it out. And third notice have been received in
Well, in this case, there is a office note, my lord, on.
Who are these people, respondents, whom you have not been able to serve?
Yes.
Who are these? 4 to 8, who are these? Is it an application for what?
Lord, the second appeal filed, my lord, actually against, dispute is against the government, my lord.
Then why, let us
They-
remove,
they
who are
also
you?
Neighbor,
I'm appearing for the State Council of Political
Standing counsel.
RSDU.
You are appearing for
RSDU, Your Lord. Soil conservation.
soil conservation.
dispute is against them.
Who are these 4 to 8?
The nearest person, my lord.
Huh?
They are also, my lord, interested person, my lord,
What is the suit for?
for declaration of possession, my lord,
Against whom?
against the, my lord, respondent,
State,
statement,
not others.
not our.
Let us strike up their name.
Yes.
Mr. H. Das, the learned counsel appearing on behalf of the applicant submits that the opposite parties number 4 to 8.
This higher copy has not been served to us, Lordship.
Wait, not necessary.
Sorry.
4 to 8.
Sorry.
Are not necessary in the instant proceedings, taking into account that no relief has been sought. You are the plaintiff?
Yes, my lord.
No relief was sought against the opposite party number 4 to 8 in the suit, and they also need. Did they appear in the first appellate court?
Yes, my lord, they appeared.
Did they file a written statement against you?
No, my lord.
No relief has been sought against the performer opposite party number. Taking into account the above, the names of the respondent number 4 to 8 is struck off. Which the Mr. Who died?
The sole appellant. Appellant.
Sole appellant died. You have not given copies to him?
Earlier PS Deka learned PS Deka was there. Now today I have not.
Why there is a delay of 338 days?
Because my lord, after the date, my lord, my lord, I have stated in paragraph 2, my lord. In I number 295. I dispose of the
Now tell me, his father expired.
yes, sir.
His father expired when?
His father expired, my lord, but on 3/2/18.
Huh?
The date of death 27/1/18.
27/1/18.
Yes.
What were you doing? You knew about this case?
Yes, my lord, I know, my lord.
Not you, your client knew about this case.
No, no, he found my lord, he was searching in the mobile phone, my lord. Thereafter he got there was a reflected dispose of. I dispose of, he has a wrong impression. Thereafter I have beat my
So
lord.
he was not bothered.
No, he was,
You have only brought in his botheration.
no, thereafter,
You go and meet your client and tell him that look here, oh, your case is there. Then why didn't you inform him earlier?
earlier there was no phone, the mobile phone was not working because after the death of
The
his
age
father.
does you keep on visiting your
all
the
evidence.
Walpara, wherever you do your cases, go and visit out there.
No, but
And
in
every client out there?
marketplace, he has met me.
Huh?
I
Very good
I
excuse.
did not recognize also. I did not know him earlier.
You see, he died on 27/1/2018.
18 months.
Now, you came to learn when? Immediately about the case when? When did you come to learn?
19.5 when the applicant meet. 19.5/19.
When did you come to learn from the photo that this person, because you knew about the pendency of the case and the applicant herein was
He
directed.
has informed me.
He was also, no, did he inform to you immediately?
No.
Then?
Did not. His son did not inform.
Then?
Father is a young person. Father,
No.
25 years
Generally,
old.
who is the applicant number 3? Applicant number 3 was looking after this case. He should have
Ramzan.
informed it was against my father.
Now Ramzan Ali meet me, my lord.
Then?
Ramzan Ali. Yes, Ramzan Ali here.
How many courts the suit has gone against you?
Title suit was filed, my lord. Thereafter, my lord, title appeal was filed. Thereafter, remand back.
How many cases? It's a case of remanding.
Yeah, remand back. Thereafter again, my lord.
Then
Thereafter again, my lord, the government, my lord, disposes me, my lord, opposite side disposes me. That thereafter, my lord, we file.
where is the impugn order?
After we are made, my lord, it was decreed in our favor.
Then why are you here?
Now, subsequently, again, file, we have to file case, my lord, because
Huh?
government disposes us, my lord.
What?
Government, my lord, side, my lord, they have constructed house, my lord, office. Yes. Paragraph
No, your suit was dismissed.
dismissed, my lord.
Then the first appeal was dismissed.
First appeal was no, my lord. Second, my lord, round of it.
I'm not concerned. We are concerned with this second round only.
Or
Second round, your suit was dismissed, appeal was dismissed.
dismissed. Thereafter, we have filed
What was the suit for?
suit for right their interest and my lord, and recovery of possession, my lord.
For why?
Because my
It
lord,
is your land,
yes, not my land,
Patta land.
Patta land. It was become fast. It was become fast. That's why thereafter, in first appellate court, my lord, the decree it suit in our favor.
Then why did the trial court, this court didn't do so? Let us see your plain.
Yes, my lord, put
So your entire case is against the state.
yes,
They have dispossessed you.
yes. Subsequently, they have inducted the 3 person here to occupy some land. That's why they were.
Counterclaim was dismissed. I hope the names of the respondent numbers and Mr. Ether submits that the Learning Council submits that the opposite party number 4 to 8 are not necessary in the instant proceedings, taking into account that the respondent numbers 4 to 8, that the plaintiff, who are the appellants, who are the plaintiff, have not sought a relief against the said respondent number 4. Taking into account the above, the names of the respondent numbers 4 to 8 in the instant application is struck off. The counsel for the applicant is directed to file an application, a fresh memo of parties before the registry of court on the basis of the instant and on the basis of the instant before and on the basis of the instant order the and the registry shall struck up the name shall make necessary changes in the court as well as its So, Mr. T.R. Gogoi
T.R. Gogoi, Lord.
appearing on as Mr. T. Deori appearing on behalf of the respondents submits that they have not received a copy of the application as well as the memo of appeal. Memo of appeal. So, Mr. H. does the Learned Council submits that Mr. H. does the Learned Council submits that the copies of the application as well as the memo of appeal shall be served to them by Monday. List the matter again on 27th of May.
But our name should be reflected in court.
The names of Mr. T.R. Gogoi and Philip Devi be reflected.
My friend is appearing for the Standing Council Soil Conservation as respondent number 2 and 3. I am for respondent number 1, G.I. Asapur.
Sir, you are going to keep your name in the
Lord.
Thank you. Yes, nothing remains.
The case is paid.
Is it stay?
Lordship, earlier it was paid.
Then?
Then it was
Put it, put it. 19/9/2007. No. You stayed as I think they must have shown it as post on the ground that there is a stay. Now, if I do not put stay as till returnable date, the next Munsif is directed not to render the final verdict. That's all. But the defense evidence should have been carried out. Now, what has happened? Why you are not being able to take steps?
But not a direct brief. The council also tried to contact, could not contact them.
Don't worry. We dismiss your petition, matter will get. If this is an application under Article 227 of the Constitution challenging the order dated 12/2/2007 passed by the Learned Court of the Munsif, North Salmara, Abhayapuri, in title suit number 15/1993, whereby the Learned Court below had rejected the prayer for further adjournment to adduce evidence on the ground that the plaintiff have already exhausted the various opportunities so given and even thereafter also on 2006 as well as on 12/2 or 12/3 well as on 12/2/2007 no evidence was filed. I've heard the learned counsel for the petitioner, Mr. C. Sharma, and have given anxious consideration to the matter. This court has also taken note of that all these while, since 2007, the matter has been pending for the last 14 years on account of no steps have been taken by the petitioner. Be that as it may, this court, taking into account that the matter has been pending since decades on account of steps not being taken, and further, the suit of the year 1993 has been pending. Although there was no further continuance has been pending, have taken up the said instant petition for disposal at this stage itself. This court have duly taken note of the provisions of Order 17, Rule 1, which mandates that the permissible adjournments that can be given at a stage of a suit is 3 adjournments. In the instant case, the learned trial court have duly taken note of that the said adjournments have already been taken and it stood exhausted even before 2012-2006. Then also on 2012-2006, no evidence on affidavit was filed, and thereafter also on 12/2/2007. Considering the above, this court finds no good ground for interfering with the even on 2012-2006. Considering the above, this court finds no good grounds for interfering with the order dated 12/2/2007, for which the instant petition stands dismissed. The learned court below shall proceed with the adjudication of title suit number 15/93 in accordance with law. The registry shall intimate the instant order to the learned court below forthwith.
This case was for restoration of this year below.
Which one?
The case was.
Which case was dismissed for default?
Yes.
Where is the order of dismissed for default?
Case number 10. 7/12.
For not taking steps. Order 2 and case number 33 of the 2017. This is an application for restoration of the accompanying CRP number 293/2007, which was dismissed for non-prosecution on by virtue of the order dated 10/12/2012. By virtue of the order dated 7/12/2012, whereby this court made it clear that if steps are not taken on 10/12/2012, the petition shall stand dismissed without any further reference to the court. This court have taken note of that no such steps was being taken. And as such, the accompanying CRP stood dismissed for non-prosecution. Stood dismissed. This court further takes note of that even thereafter also, only after a period of 5 years, the instant application was filed, which categorically shows the total lack of diligence on the part of the petitioner. Under such circumstances, this court also finds that on account of lack of diligence, the instant application cannot be allowed. In addition to the above, this court have also taken note of the order impugned in the accompanying CRP number 293/2007, whereby the order dated 12/2/2007 passed in title suit number 93. What is the suit number? 15/93, wherein an order dated 12/2/2007 passed in title suit number 15/93 have been impugned. A perusal of the said impugned order reveals that on various occasions times was taken for filing of the evidence on affidavit by the plaintiff, which was not done. Long before 2012-2006, the period stipulated under Order 17 Rule 1 had expired. This court finds it relevant to take note of that Order 17 Rule 1 categorically mandates that there should not be more than 3 adjournments at a stage of a suit. In the said case, in the instant case, the plaintiff had sought for more than that and were also granted more leniency. Under such circumstances, this court is also of the opinion that the order dated 12/2/2017 did not call for any interference under Article 2 to 7 of the Constitution. Consequently, this court, on taking into account the merits also, is of the opinion that this is not a fit case for restoration, which has been dismissed for non-prosecution in view of the order dated 9/12/2018. 9/12. 7/12/2012. I stand supposed the registry shall intimate the learned trial court to proceed with title suit number 15/1993, pending before the Court of Ubhayapuri, Munshi Ubhayapuri, in accordance with law 40.
Okay.
Yes, please respond number 8.
We came to know about expired for
Is performer. Not necessary, remove it. Not necessary. Performer, what is there? Don't unnecessary and delaying these matters, that doesn't help. The learned counsel appearing on behalf of the appellant submits that the performer respond number 8 had expired. And as such, the appellant need not file any substitution application taking into account that the state performer respondent that the appellant does not claim any relief against the performer respondent. Accordingly, the name of the performer respondent number 8 is struck off. This court have duly taken note of that the LCR has been received. Accordingly, lists the appeal for hearing in its usual course. Parties are given the liberty to file applications for early hearing of the matter. The counsel for the applicant is directed to file a fresh memo of parties showing that the respondent number, performer respondent name of the performer respondent number 8 has been struck off, and before the registry of this court by 25/2024, and on the basis of the said fresh memo of parties and the instant order, the registry shall make necessary changes in the cause title as well as also update the same in the CIS. What in time order? 2020 matter, you are still in the interim order. Where's the interim order?
IA 4.9.
This is an application under Order 41, Rule 5 of the Code of Civil Procedure 1908 for stay of the judgment and decree dated 1/11/2019, passed in title appeal number 4/2019. This court have duly taken note of that the coordinate bench of this court had already admitted the appeal on 4/3/2020 by formulating a question of law. It is also seen that this court have also directed the appeal to be listed for hearing as the LCR has been received. Under such circumstances, this court therefore disposes of the instant application, thereby directing that the judgment and decree dated 1/11/2019, passed in title appeal number 4/2019, shall remain stayed till the disposal of the connected appeal. Yes, why it is in the defective section?
My lord, 3 numbers of IAs have died, my lord. The appellant number 1 has died.
Then why it is still in defective
My
section?
lord, the defects have been cured. However, the IAs have not been tagged with the record. My lord, I have the filing numbers of the IAs.
That is already there. What is this, 1894? These are the applications.
My lord.
Which are the applications?
My lord, filing number, serial number 844, 845 and 846 of 2023.
That is already there, IHC number. The learned counsel appearing on behalf of the appellant submits that the defects which were there in the 3 interlocutory applications have already been cured. So taking into account the above, list the matter on 5th of June 2024 along with the said interlocutory applications.
I do. See, if I may, my we have withdrawn from this matter. The brief has been returned. We have withdrawn from this matter. Item 23. The brief has been returned to the client.
This is 23.
Yes.
Not 22.
Not-
Yes, what is this? You can't withdraw like that. You know how to withdraw.
Yes.
Don't come up with all this type of thing. Yes, Mr. G. Chaudhary is, who is Mr. G. Chaudhary? Learned counsel for the appellant. You are there? How many persons are there? Mr. A. Sattar is there. Mr. G. Chaudhary appeared in 2023. Huh? You are appearing?
Right.
Somebody appeared on the last occasion and showing.
Perhaps I appeared, my lord, on the absence of Mr. Sattar, my lord. It appears as a property.
Respondent number 1 and 2 is represented. You have withdrawn. Have you mentioned anywhere how you have withdrawn, Mr. Counsel? You file your affidavit and where is your notice? You can't withdraw like that.
Yes.
Because earlier one Mr. G. Chaudhary appeared, learned counsel for the appellant submits the response number 3 had expired and the application for substitution has been filed, which is not on record. Who is G. Chaudhary? You are
Perhaps I appeared, my lord, I remember, my lord, I appeared, perhaps, my lord, when Mr. Sattar was absent on that particular day, my lord. I'm not putting the
Mr. What's your name?
Yes.
G. Imtiaz, the learned counsel appearing on behalf of the appellant submits that they have already returned the brief to the plaintiff, to the appellant. However, there is nothing on record to show that. Under such circumstances, the counsel is directed to file an affidavit along with any documents evidencing that they have returned the brief to the appellant and the appellant has due notice about their withdrawal from the instant case. List the matter after 2 weeks.
appeal admitted,
Service complete.
service complete, LCR has come.
Okay.
LCL court.
Appeal admitted, yeah. Service being complete and LCR having been received, list the matter for hearing in its usual
Lordship.
course.
But it is 25, sorry, I'm for 25.
Huh?
From 25.
24,
I am for the respondent number 1 to 8, man.
1 to 8, 9 to 11 has filed, 9 to 12 has filed.
Yes.
13 served, 14 served, LCR received. So, same. The 25 is same,
Most of it.
same order. Appeal, service complete, LCR received, list the matter for hearing in the usual course.
My lord,
Yes, what is 26?
my lord, proposal respondent number 2, apparently not found.
Why is it, do
I've
we
taken steps
require them or should we remove them?
My lord, because he
He's
was
the
the
husband of
husband of
husband of
husband of the
the
petitioner.
appellant, Lord.
appellant. Husband of the appellant, who was the person who is the suit for specific performance of contract. I was the defendant. The husband took the money that has been alleged.
What is the matter about?
Suit for specific performance of contract.
Okay. Then
Then it was decreed, then my lord, the appellant
why you are making performer?
was
Is he relevant?
Not, not that person.
So we struck off.
Well.
Husband of yours.
Yeah.
And you don't know his address.
But I have sent the registered post and it has been, it has come in the office.
Mr. Roy Chaudhary,
Malad,
you send it registered post. You are the appellant. You are his wife.
Malad,
Are you staying together or not?
Malad, that is not known to.
Hey,
The
the husband.
lady has not come to me, Malad, directly. It was some of the advocate was who has told me to.
Now, whatever may be, it's a husband. Either you want to strike off or do whatever service. It is inconceivable.
Same appellant address and the performer respondent address is the same.
So both of you stay together.
Malad.
But the appellant has not been able to serve to the performer respondent. What do I do? Strike off. Mr. P.K. Roy Chaudhary, the learned counsel appearing on behalf of the petitioner, appellant, submits that the presence of the performer respondent number 2 is not necessary in the instant appeal, taking into account that no relief has been sought for against the performer respondent number 2. Accordingly, the name of the performer respondent number 2 is struck off. It is also seen that the service is otherwise complete and the LCR has been received, for which the list the matter for hearing in its usual course. However, liberty is, however, given to the parties to file an appropriate application for filing application for early listing of the matter. File a memo of parties between 2020 and 25. Fresh memo and parties and all the corrections. File a fresh memo of parties because of removal of performer respondent number. Yes, what are these?
My lord, this IA is for substituting the heirs and legal representatives of the deceased respondent number 1. The representatives are already on record as Sri Vishwajit Das, Sri Monojit Das, and Lipika Chaudhary. The death of the deceased respondent number 1 may be recorded.
They are already there.
Yes.
So these IAs are just for the sake of it.
No, this IA is for recording the death of the.
Okay.
deceased
This is
respondent
an
number 1.
IC 2365/2022. This is an application filed in terms with Order 22 Rule 2. Order 22 Rule 2 has been filed to bring on record that the respondent number 1 had expired on in the year 2000, in the first part of the year 2021. It has been further mentioned that the estate of the respondent number 1 is duly represented by the respondent number 2, 3, and 4. Full stop. Taking into account the above, the name of the respondent number 1 is struck off, and I sense disposed. The other application is same. Itu tu bela kata ko 2366 respond number 1.
Right.
Not as per the operational method, notice has been served on all the respondents. Respondent number 2 expired.
What to do? 2 months.
What?
2 months.
What?
The Mr. His office note is already there on 7/6.
No.
Then how do you do? On the last occasion also I gave you time.
Method, only problem is that method, or they could not collect the name of the method.
Understood?
There is a problem. Otherwise, method, I cannot also make a fair for.
No, that you
Striking off.
can't. That is why I am not disturbing you with that. But the fact remains that on 7/6/2022-23, the respondent number 2 has already, it has been mentioned out there. And on the last occasion, 23/2024, you took time. I gave you time for that.
That's right. Otherwise, my lord, I am extremely sorry, my lord. We could not collect. They also could not collect. We are helpless. We cannot also make that, my lord, any pair for striking off.
You are a plaintiff. They are a plaintiff.
Yeah, even then, my lord, one more chance may be given.
Hmm?
One more chance may be given.
At the request of the this is the matter of the 2 months. Thereby enabling the applicant as a last chance to take appropriate steps.
How many days, my lord? 2
Huh?
months. 2 months. Apply.
I have taken step on matter 19/11/2023 in respect of respondent number 1. I have respondent number 227 already appeared.
They have appeared. What about respondent number 1?
Respondent number as per office note stated that family members did not receive the notice. Office note dated 24/5/2020.
The learned counsel appearing on behalf of the appellant admits that he would like to take fresh steps upon the respondent number 1. The counsel for the appellant is directed to take fresh steps by way of registered as well as usual upon the respondent number 1 within 7 days.
So that we have already taken 2 times steps.
So then do whatever it is you want to take by way of trustee. The learned counsel appearing on behalf of the respondent appellant submits that in view of the office note dated 7/2/2024, the appellant may be permitted to take effect justice service upon the respondent number 1. List the matter again on 5th of August 2024. Steps be taken by way of justice routed to the registry of this court and file an affidavit upon the respondent number 1 routed to the registry of this court and file an affidavit of service on or before 22nd of July.
Apply.
A Khonigor is the out of business.
Who?
A Khonigor.
The learned counsel appearing on behalf of the appellant submits that taking into account the office note dated 22/3/2024, he would like to take appropriate steps. List the matter after 2 months. 3 months.
Okay. So is the content appeared as yet? So the etiquette from the content number and the tweet but as part of it.
9 not found.
Family member refused to accept.
Who is respondent number 9?
Page 6 number Punjab.
How many people are there?
Earlier the number 1.
It is service is impossible. 22 also not done.
21 and 22 I am paying also.
Huh?
21 and 22 I am paying.
You are paying for 22.
21 and 22 it's okay.
Who is paying for 2 to 8?
No one is appeared, but 3 all are served.
That is okay. Taking into account that the service upon the respondent number 9 is not complete, list the matter. The appellant is directed to take fresh steps upon the respondent number 9 by way of registered as well as usual within 7 days. List the matter of the completion of service.
For the appellant number 14 died.
You do whatever it is. I am not going to say anything. You know appellant number 14 then. The moment I say something, then I give you time, then by tomorrow you will ask for
Her
limited.
name is required to be struck out.
Huh?
Her name is required to be struck out. Okay.
Take first steps on 9. Yeah. 33. All notices were served by hanging on the wall of the house that the respondent refused to accept. LCR received by the section. What is it? Hanging in the, yeah. What has happened as regards the register post? This is the matter again. After 2 weeks, giving detail as to what is the fate of the steps being taken by way of registered post upon the respondents. Numbers 1 step.
Service upon respondent number 2.
PR4 is dead.
4 is dead. No, we don't need him.
4 and 7 not necessary.
Not necessary. Lordship, LCR has not been called yet. It was admitted on 26. 5/8/20.
Madam is appearing. You are appearing in this matter? For respondent number 1? Yes.
Yes, it. I am with Mr. H. M.
You are appearing for whom?
My
Respondent
name,
number 1.
Nepurjan Devi, maybe I am preparing.
Hmm?
My name has not been good, but earlier also there is an RSA by Nepurjan Devi. That is also I was there. Maybe I am with H. M. Chowdhury.
You are the sole respondent, huh? You are the main respondent.
Yes, Lord. So far I remember.
Mr. B.K. Bhagwati, the learned counsel appearing submits that the name of the performer respondent number 4 and 7 may be struck off, taking into account that they are performer respondents and no reliefs have been sought against them. Accordingly, the names of the performer respondent number 4 and 7 are struck off. Ms. R. Chaudhary duly appears on behalf of the respondent number 1. So it is also seen that the service upon the other performer respondents have been duly complete. Taking into account the above, this is the matter. And it is also seen that by an order dated 5/8/2023, the appeal has been admitted by formulating substantial questions of law. However, the records of the learned trial court as well as the first appellate court have not been called for. So taking into account the above, this court directs the registry to call for the records of the LC of the learned courts below. To list the matter for hearing immediately upon receipt of the LC.
Apply.
Lordship, as per office note dated 7/2/24. Service epic.
6 is dead.
Yes, respondent 6 is expired on 7/7/20.
Huh?
Respondent 6 expired.
Then
After going to the office note, I got to the.
Mr. A. Dekal, learned counsel appearing on behalf of the appellant submits that he may be given certain time for taking appropriate steps in view of the office note dated 7/2/2024. List the matter after 2 months. In the meantime, it is further directed that the appellant is directed to take steps upon the respondent numbers 4 and 5.
5 is refused by the respondent.
Addressee move upon 4 and 5 by way of registered as well as usual within 7.
Case for failure not been received by the sector.
Yes, what is this 50,000 business?
Market should go for
I know,
50,000
where
was
I
the pay was granted on copy that 50,000 deposit for
check to pay. Check to deposit of paying the registry within 10. What is this? The money decree?
Yes.
What is order 20 rule 5? Order 20? Just put for money suit. Court to state its decision on each in a suit in which the issue has been framed. The court shall
state
state its finding. Then, how is it relevant?
for case of the page 40 title affidavit for judgment.
Huh?
Page 40 title affidavit for judgment.
Huh.
That was on all the issues. But the order 20 to 5 days, page 40 or 45, but the number 3 and 4.
Whether there is cause of action, whether the plaintiff defendant took a loan of 2 lakhs from the plaintiff, whether the plaintiff is entitled to recover it, or is entitled to the decree. 2 and 3, 4 are redundant. One is cause of action. Then 1 has been decided, 2, 3, and 4 has been decided. Then what is there? And what is order 41 rule 31? Recently, the Supreme Court has categorically said not necessary in knowledge that when this has been done. Let us dismiss your appeal.
Some other
Why unnecessary take steps in all this? Today I have not yet dismissed one second appeal. Yes. Let's dismiss it. Let it.
on a
Huh?
on a hearing date.
No. This is
Today
not
I have
necessary.
prepared for
Hello. You are paying for the other? Fantastic. This is the matter on, we dismiss it on, you want it on a hearing day, go to for a gracious dismissal, okay. This is the matter on 21st at 2 p.m. Matter
Okay.
heard.
Okay.
Allowed to withdraw
What?
54. Allowed to withdraw
Withdraw?
That 50,000 they want to withdraw.
Don't. On 21st, I dismiss, you take the 2 lakhs.
Okay.
At 2 p.m. At 2 p.m. Huh? Yes.
So the service upon respond number 20 is completed. 1
Yes, what is this? Oh, that matter.
is
Yes, what is that?
service
Injunction, something is there?
Lordship, I was appealing on behalf of the respondent number 3.
took service, they have to register both. And as well as Dusty upon respond number 20 is completed.
Who is that?
I appear for respond to Madam.
2.
Yes, I.
Yes, Mr. Counsel, you are appearing for whom?
I'm for the respondent number 3, the executor, Mr. Somnath Chatterjee. My
Huh?
lord, respondent number 3, the executor in the appeal.
You're appealing for respondent number 3,
Lordship, respondent number 3.
and you,
My lord, Mr.
the
Basu.
counsel on the right hand side of me.
My lord, Mr. Basu
My
is
lord,
my advocate.
My
on
lord,
record,
I am
my lord.
also appearing, my lord. I am being led by Mr. Sharma.
And
You
I'm
both
led
of you
by
are
Mr.
appealing
yes,
for respondent number
Yes,
3.
3. And
my lord.
ultimately, we are both led by Mr. Ratnako Banerjee, my lord, senior advocate, my lord, who is unfortunately not here at the moment. He was supposed to be.
And who is appealing for respondent number 1? You.
Respond number 1 by the services office. We attempted to serve upon the respond number 3. Otherwise,
Who is the plaintiff?
Plaintiff, my lord, is dead, my lord. I am the executor, my lord. The plaintiff is dead. We had filed an application for substitution, which is pending. My lord, in the meantime, my lord, the plaintiff is dead after the suit was filed. Now, my lord, the papers which are there here, my lord, all the papers of the learned court below are not here. I would like to use an affidavit, my lord, to bring on record all the papers and affidavit to this application also, which is now pending before this court. Kindly give me an opportunity to file my affidavit, my lord.
Okay.
To bring the record all the papers of the learned court below.
You see why the matter has come up because of the fact that they want to use the shares. That is what.
we
My lord,
want, basically we want a clarification of that status quo order. That the status quo order is not dissenting us for exercising our rights over that here. Because it's a joint
I
share.
will show, my lord, that is not possible in view of the orders passed by this honorable court, which has
And
been
Calcutta.
confirmed by the
Mr.
honorable
Sharma,
Supreme Court.
we have no problem in giving what you call
Affidavit.
audience through video conferencing. It is very well. But the problem is, I don't know, am I short of hearing or not? None of here can hear what you are saying.
I'm
It's
very sorry.
difficult.
My lord.
Maybe the audio system out here in Guwahati High Court may not be
But
up to the
but your
standards.
lordship is told absolutely audible. I can hear my lordship very well.
That is what.
Very well.
So
Lordship is absolutely audible.
it is
My friend
happening
is
something like a one-way traffic.
maybe something has happened. It is my
So on the
unfortunately
next
my
day,
bad luck.
on
My
the
lord, we will
next
come
day,
physically, my lord, on the
We will
unless
come
the
physically.
situation
We
does
will
not
come.
improve,
We will come physically. We will come physically.
and doesn't remain as a one-way traffic.
No.
So
We will
I
come.
think you need either you be present or
No, I will be
better
present.
off.
I will be
My lord,
present. Madam,
we
my
will be
CEC
present physically.
No, madam,
Better.
Mr. Banerjee is here online. I hope he's more audible than me.
My lord, I'm sorry, my lord, if we are not
Uh,
audible, my lord.
Very difficult to hear you, Mr. R. Banerjee, senior advocate. Very difficult. I can't hear you at all.
I'm so sorry, my lord. I'm so sorry, my
Yeah.
lord. It will,
Maybe
my lord, it
something
will
must be wrong. Hey, ask these people because all the video conferencing matters is very difficult. It's not audible for this court. Something must be wrong.
But
We
we
will
can
get
hear
it right on the
lordship. We
next
can hear your
occasion.
lordship.
My lord,
Anyway,
my lord, we
when do
can
you
hear
want
my
the
lord
date?
very clearly. My lord, we can hear my lord very clearly. My lord, we can hear my lord very clearly.
Yeah, because of the fact that I'm just saying something in the mic itself.
My lord, it's always been a pleasure, my lord.
Maybe
We
there
can,
must be some problem here. Anyways, when you are going to file, Mr. Sharma, you said that you are
But
going
yes,
to file.
we will like to file an affidavit, my lord. So kindly, my lord, we will kindly give me 4 weeks time, my lord, because in between 2 weeks, my lord, we are closing for the
my lord,
Calcutta. We have
that's
a
the
summer holidays. We are
Okay.
closing for our
You do one
summer
thing,
vacation.
you file your affidavit by 14th of June.
My lord, instead of 14, my lord, I was praying for kindly give me time.
No,
till-
no. Mr. Sharma, you file your affidavit by 14th of June. We have it on 19th of June.
My lord, we are in some difficulty that week, my lord. Kindly give me a week beyond 14th, my lord. I was
Why?
praying, my lord.
You
We are
want 4
closing.
weeks time, I've given
No,
additionally
4
another 2
weeks.
days and now you are
Ki-
coming down with this.
4 weeks means
Mr. Sharma,
kindly-
when you, Mr. Sharma, when you,
You want to be, first of all, the question of filing an affidavit in an FAO is completely misconceived. You want to file it, I am giving you an opportunity.
my lord,
This court never allows an FAO in an FAO for filing an affidavit. Because if you see the provisions of Order 41, the concept
Correct.
of filing an FAO, there's no affidavit. Because the FAO is not never on an affidavit.
my lord,
I
here,
don't know if it applies in the Calcutta High Court where you file an appeal out there you required to file it on an affidavit. Here it is not required. So
But yes.
if we believe out here, the CPC which applies in the Guwahati High Court is different.
Correct.
So
my lord.
I am giving you an opportunity for
Very
filing
well.
it.
We'll take it.
Don't take it. When if I'm giving you something out here, the small one or anything, don't ask for the moon.
No,
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 I'm
my lord,
grateful.
we'll take
I'm
it. My lord,
We
kindly,
will
my lord,
fix it
submit
on
as-
19th. You file your
Very-
affidavit by 12th now. 2
No,
days
my lord,
before.
kindly give me, but only my lord, on
I'm
19th we have
fixing
some
it on, you file
difficulty.
your affidavit by 10th of June.
Kindly give
My
me
lord,
the
there's some
14th.
documents which are
Okay,
missing. my
you
lord.
file
Some-
your affidavit by 6th of June. Don't take this court for granted, Mr.
No.
Sharma. I've given you a
Mr.
good
Sharma.
time out here till 14th of June.
I
Then
followed
why,
up.
why you're taking this court for granted and asking time?
I'm sorry.
The
I'm
question
sorry.
of granting you any further time does not arise. You were to appear before this court. Let us
I'm sorry,
consider
my
this
lord.
FAO now.
I'm sorry, Lordship.
Let us
Kindly
hear it.
pardon me.
I have no problem. Let us hear the FAO now. We'll take
Kindly
it up the
pardon
FAO.
me. Kindly, I'm so sorry, my lord.
Don't come up with these things. You may say it to many other courts, not before this court. Be careful. The record reveals that the service upon the respondent number 1 is yet to be completed. However, as regards the survey, the respondent number 2 and 3 are duly represented. Mr. R. Banerjee, the learned senior advocate appearing on behalf of the respondent number 3, submits that
Three.
some accommodation may be given for the purpose of bringing on record certain documents by way of filing an affidavit. So taking into account the above, list the matter on 19th of June 2024. The affidavit be filed by 14th of June 2024.
My lord, only one request, my lord, may I make? My lord, one request. My lord, one request, my lord, may I make?
They have wrongly quoted the ID number of the Demat account
Of who?
of HDFC Bank. So that I
You take that ground on the next it.
My lord, is it possible, my lord, on the 20th, if it's possible, my lord?
Huh?
On the 20th, my lord, if it's possible. My lord, on the 20th of June, my lord, if it's possible. Otherwise, my
20th,
lord, no difference.
20.
20, my lord,
Okay.
20th.
20.
20. I'm great.
We'll have it on 20.
I'm so grateful. I'm so grateful.
38.
So
Yes.
still in time. This application is in fact
Time. Don't allow go to. Allowed.
highly important.
that is the Pakshik.
What is this? You're asking for packaging?
Yes, my lord.
What have I done?
My lord, that is a page 29, my lord.
Huh?
Regarding construction, my lord. My lord, I'm talking about here. I'm my lord. I have
It
no
is
material.
somebody else order.
Yes, that is there. My
No
lord. Page-
construction be made over the scheduled B land by the opposite party. It is however clarified that since this order is passed, the opposite can be at liberty to come for modification.
Yeah, only
So
thing, my
therefore you have come for modification.
yes. So only thing, my lord. This is not my lord.
Hey, main file be
My lord, subject.
Yes.
The outcome of the case, my lord. Here I'm talking about the construction of the in
What
the
do you want to do?
in the first floor only, my lord. In the first floor, these iron rods and pillar are already there. My lord. This is the only thing. Ground floor is always there. Constructed way back, my lord. I have the photograph also, my lord.
Is a suit based on title?
My lord.
Then how is 64 being applied?
Not applied.
Who has claimed adverse possession?
They. No, they are not claiming, my lord. The court has made out a third case, my lord, of the adverse possession.
I'm the purchase. I purchased the plot of land. I'm there.
Then why is this question of 64 123 brought in?
That does not come, my lord.
Then why did you raise it? Why did you raise it?
I will not raise.
No, why is that a substantial question of law?
Well, on that ground, my lord, my decree has been set aside by the learned appellate
Okay.
court.
On 64?
On 64. My lord, trial court decreed the suit. Appellate court made out this third case of the adverse position and set aside.
But the suit is based on title.
Suit is based on title.
Your suit
Mine.
is based on title.
Yes, sir. Of course, sir.
Case of 64.
Yes, obvious.
It may at best, if you take a ground, did you pay for a ground of adverse possession?
Absolutely not, sir.
So it is not 64. So we then strike up the second year. But the trial court did it. First appellate court, first appellate,
Only first appellate
which was
court
never a case.
No, never a case. It was never a case. It was never prayer of the defendant also. We also not say.
We'll do one thing. We'll take up this IA and this matter together on 28th of May.
All there. Last week of May, I may not be there.
He's there. Mr. V.K. Borua is there. Okay. I'm not there in the first week, so I can't impose upon the other side. So let it be on, yeah. Not on 29.
Let it be on 29.
29 is Wednesday, not
no,
possible. It has to be on 30.
28 and 30. 30.
30? At the request of both the parties, the matter stands adjourned to be listed on 30/5/2024. So it is observed that in the circumstance, and observe that this court may would try to dispose of the main second appeal, taking into account that the records are already available. So in the circumstance, the said second appeal cannot be disposed of, the application for vacating of the order could be considered.
All right.
Yes, what is this?
This is a continuation of delay. Some
For
delay
what?
is on my part.
That day one matter came up and you were not there. I did not dispute for default.
Sir, actually, I did not come aware of that. Actually.
Review of whose order? Huh?
Yes, sir, actually review order of this one, page number like this. Page number 30, Lordship.
Correction.
Page number 30, Lordship, and it's 30.
Hello. Issue notice. I cannot issue notice. Issue notice upon the respondent. An application for condoning the delay of 698 days in filing the review application. Issue notice. Mr. I'm not going to issue notice. I'm dismissing your petition, right?
Lordship, kindly listen.
No.
Please,
What is there
let
to
me
listen?
say something.
What did you say in your petition? Tell me. And let me read it. That the petitioner begs to submit that a review petition could not be filed in absence of correct advice from the advocate and illness from long time, and for further Guwahati to Chandigarh is a long distance which is also a cause of delay to file. How many times you have appeared before the court? Before me itself. That there is a delay of 698 days and was not willful. Matter over. Where is your medical certificate?
That is, I was ill.
Mr. G.D. Demand, the learned counsel submits that he would like to file an additional affidavit in the matter explaining the delay in more detail. Taking into account that this court is not convened with the explanation as stated in the interlocutory application. I acknowledge.
Lord, fixed date, right? It's like,
If
10,
you don't file, you may have to go to Chandigarh tomorrow. When you are coming, you have your tickets.
I've
You
going.
file your affidavit, then may come in. Affidavit, then may come in.
Okay, Lord.
Yes, first time.
My lord, it's a distance of my lord.
Issue notice. You are APA.
For
We
response
have
number
to-
one.
Response number 1. He had expired.
No,
No, but the
appellant
evidence is-
expert.
Sole appellant.
So
You file an objection.
Yes.
Three issue. Yeah, कोई दिक्कत, notice issue कोई दिक्कत. He accepts notice on behalf of so and so.
Response number one.
Response number 1 and submits that he would like to file objections. You file your objections in all three. Leave the matter after 4 weeks.
Can I add some other grounds which has not been taken?
That
might
is
be-
what Mr. Demand I have stated.
But
As I am not satisfied asking you to file an affidavit
Obliged,
bringing
obliged,
more
sir.
detail.
my lord, there are other respondents.
Other respondents, how many? You is paying for response number 1. Who are the others?
If other respondents are my lord, there are other respondents of 12. And 130 financial corporation code is their idea.
Who is the appellant?
If that my lord, Suren Gopal or original right? Right.
Issue notice making it returnable by 6 weeks. Who take it? Huh? Steps be taken. As regards the respondent number 1, Mr. B.K. Jain appears, who submits that he would like to file objections. As regards the others, he's given the liberty to do so. The respondent number 1 is given the liberty to.
Obliged.
Steps be taken by way of register along with it usual upon the respondent numbers 2 to 30
My obliged.
within by 25 2022.
Happy, sir. The last location, there is a direction of Honorable Court, take steps on the correct address of the respondent. What has happened, Lord? Yesterday I've been informed that there is a settlement has been arrived at between the parties. So can it be taken away the next week, Lord?
At the request of the learned counsel for the appellant, matter stands adjourned to be listed again on 31st.
Yes.
of
Obliged.
Lord. What is this transfer? From where to where?
From Obhaipuri to
Huh?
From Obhaipuri to I'm appearing for the respondent. Husband.
Abhayapuri to what do you do?
Well, earlier, the husband was working as a constable under the SSB, under the CISF. Later on, he was terminated from service. Presently, he is unemployed.
Husband is unemployed.
Presently unemployed, without any service.
And you?
My parental father.
Where is the case file?
Yes, Obhaipuri. And marriage was
And he stays in Dibrugarh. And you want the divorce?
I want to take it. And here, I want to file some objection on evidence for raising some objection.
For what?
The meantime, I have some information. I have received some information that the lady already has been married with some other person, and she is residing at some other place.
Understood. That is a different thing. Whether she is married with somebody, I'm not concerned. That is not the subject matter here.
Well,
We
here
are
my only
only
submission is
concerned
that,
as to whether it should be transferred from here to.
well, my only submission is the suit is at the advanced stage. My husband has filed the evidence also, Marot. Earlier, the
Is it
suit-
there?
Evidence.
I have not appeared yet, but
It was proceeded expertise of the service of delivery of notice, Marot. Suit proceeded expertise by the trial court. Husband side, Marot, file evidence, and the presently suit is at the stage of hearing.
How did you know about the suit?
But
as per,
Petitioner is absent with steps showing for no payment has been made.
that, but these are from-
What is there? Why you are saying this?
no, these are, the next are for, they're filing a
Today is the date
maintenance
taken
petition
for
before
the
it is called.
the hearing by the to against him. What is this? How is this? It's a different case.
Well, different cases, but maintenance petition filed before the Dibrugad Court. These are the annex of documents for maintenance.
This was issued on 30/11/2023 and it has proceeded ex parte against him. When did you receive this summons? Mr.
My lord. Lordship,
The first date is fixed on 22/1/2024 and you are saying it is at the advanced stage?
but earlier, my lord, they should proceed expertise against the opposite person, wife, my lord. And then, my lord, petitioner said was directed to file evidence, that evidence was filed. And then, my lord, actually, on the last date, my lord, on the previous date, my lord, it was on 2nd of mostly May, most probably. It's 2nd of this month. Just fixed for hearing of one petition under section 65B, regarding secondary evidence. Then, my lord, the next date is fixed on 20th.
You want to file objection? Now you file your written statement. No.
Because my father expired on 18th. Order got directed to file on 2nd of May. But my father expired on 18th. So I am
Heard, Mr.
It
When so the KD Sharma, the learned counsel appearing on behalf of the petitioner, Mr. Appearing on behalf of the sole respondent. It has been brought to the attention of the counsel for the respondent seeks for an accommodation for filing their objection to the instant application. So time granted to be for 6 weeks. List the matter again on 24th of June 2024. In the meantime, this court states the further proceedings of Title 2D number 36 of 2023 pending before the court of the additional district judge FTC, North Palmyra, Abhayapuri, Assam. Till the next.
all right.